Rolling Stone, good?
Thank you
Okay.
for that. Great.
We're ready. Everybody ready?
All right, good morning. Can everyone hear me? Yes, thank you all so much for joining today. I'm State Senator Natalia Fernandez, the chair of the Senate Committee on Alcoholism and Substance Use Disorder, and I'm joined today by Senator Jessica Ramos, as well as our minority member on the committee, Rob Rollinson, and our assembly member, who is co-sponsor of the bill in discussion today, Sarah, oh my God, I was gonna say Farrah Fawcett. Farrah Souffrant Forrest. Yes, Farrah. Farrah Souffrant Forrest. But as you know, we're here to discuss Senator Ramos and Assembly Member Forrest's bill, Treatment Court Expansion Act. This bill is a critical step forward in the ongoing effort to ensure that mental illness and substance use disorders are treated not as criminal justice issues, but as public health challenges they truly are. For too long, our justice system has served as the default response for individuals experiencing mental health crises or struggling with substance use disorders. The research that we have seen far and wide is clear. Incarceration does not heal people, it does not resolve trauma, and it does not reduce recidivism, and it does not make our communities safer. What does work is meeting people where they are with evidence-based treatment, trauma-informed services, and the opportunity to recover with dignity. Recovery, as we know, is possible, but only if we provide individuals with the support and tools that they need to get there. I truly want to thank Senator Ramos and Assemblymember Forrest for championing this bill and building the coalition that we have been working with to get to this moment today. As the chair of Alcoholism and Substance Use Disorder and a supporter of this piece of legislation, it is an honor of mine to hold this hearing and engage in the conversations, put information on the records, and to give us the tools to see that we can push this bill forward to ultimately the governor's desk. Senator Ramos, would you like to say something?
I would. Good morning. Buenos dias, everybody. I'm State Senator Jessica Ramos, proud state senator representing the neighborhoods of Jackson Heights, Corona, East Elmhurst in Queens, where we were one of the communities really hard hit by the war on drugs many, many decades ago. And so even though I chair the Labor Committee in the State Senate and my line of work is usually around workforce development and making sure people's labor rights are protected, the reality is that we are feeling less unsafe at home, on the street, and we want data-driven, scientifically proven methods of ensuring that we are keeping each other safe. We know, not only from people's lived experiences, but even from health professionals, from legal professionals, that mental health court has proven to be a way in which those who are struggling can access the care that they have been neglected of for a long time. And so I always love to remind that the Treatment Court Expansion Act is really just one of two parts in order to address our great mental health crisis. I mean, before the pandemic, the statistic was that 1 in 5 New Yorkers are suffering with mental illness. The pandemic only exacerbated that. And although we don't have data from these past few years, we see it every time we take the subway, we see it every time we walk around in our neighborhoods, and we have to do something about it. Those are our neighbors. We love them. We want to take care of them, and we want to make sure that they are getting all of the services that they need. So we need more programming, we need more services, we need more mental health beds in our hospital system and beyond. And I am hoping that next year, the next legislative session in 2026, serves as a turning point in this struggle, in making sure that we are putting our court system and hopefully our health system on the way to addressing these longstanding inequities, because mental health illness has only perpetuated poverty in our communities. It only perpetuates mental illness in many of our communities, and we can stop it. We can help them get the services they need. So thank you, Senator Fernandez, for making this hearing possible. I also want to thank the Assembly sponsor of the bill, Assemblywoman Farah Souffrant Forrest, and we are also joined by Senator Rollison, who has trekked downstate despite having a 10-day-old grandchild. We needed to have an awe. It's World Mental Health Day, and babies make the world better. Absolutely. All right. Well, thank you all, and I am excited to hear everyone's testimony.
Thank you so much. Assemblymember Forrest, would you like to say something?
Quick words that don't need Assemblymember Farrah Forrest represented District Central Brooklyn, but also a nurse. And so to be the sponsor of a bill like Treatment Court Expansion Act is I feel like it is the most beautiful piece of legislation that I ever got to really sponsor, because when we talk about evidence-based, Senator Ramos said it, we want evidence-based practice in everything we do in the healthcare system. Why? Because if it's proven, if it's true, it's been tried, it's been peer-reviewed, it's been vetted, why not? Because usually when you have a EBP, what we call, it means that this is gold standard. And this bill is wrapped around gold standard level of care, because what we're doing is not working. What we're doing, where we're putting people in prisons without supports and then expecting them without the support to turn their lives around, is not working and is in fact creating crises across the state. A public health crisis and also a public safety crisis. But thankfully, we have a Senator, Natalia Fernandez, who said, look, and not only do I support this, but I want this evidence to come out. I want us to have a public conversation around this. This is, the people that this bill would impact are living in the shadows without very much options to voice out their hurt and their needs. But here, this public conversation, we're going to have everybody in this practice, because the judges are part of this practice, the caseworkers are part of this practice, the clinicians are part of the practice, the sponsors, the legislators are part of this practice. Believe it or not, this is community care. And so, I'm so excited to have everybody speak up. Please speak up, because this is the only way that we're going to make this bill the best bill that will address all the deserving communities across the state. So thank you so much. And also, congratulations, Senator.
Thank you.
Yeah,
I got a lot. And I'm really happy to be able to be here today. I represent the 39th District in the Hudson Valley, which is parts of 3 counties, Dutchess County, half of it, a little bit of Putnam County, and then jump across the river to Orange County. I'm glad to be here with my colleagues, of course, and look forward to being back in session in January to continue all the work that we're doing and we're trying to do. But I'm very fortunate to be on this committee with my colleague and friend, Senator Fernandez, and also as an extension to the discussions we're going to have today, I'm also the ranking member of Crime Victims Crime and Correction, which is another important committee to serve on. And also, just for reference, I was a police officer for 26 years in the town of Poughkeepsie Police Department. And I did 12 years in uniform and then 14 years in the Detective Bureau. And I saw, starting in 1982 when I got on the job, you know, the evolution and the change for alternatives for individuals who are suffering from addiction, who are in crisis, and who have those related issues that can cause certain types of behavior to get them into the criminal justice system. So thank you for being here. Thank you for having me, and look forward to all the discussions that we have today. Thank you.
Thank you so much. All right, let's get started. So,
Senator Fernandez, I think he's saying this could be a bipartisan effort.
I mean, he's here for a reason. So this could be. This could
I
be.
took the 7-Eleven train this morning up at 5 at the train station and down here with all of you. And I'm really happy to be here, as I said before. But thank you.
Thank you. Alrighty, so just some meeting notes. We're joined today by, as we said, judges and experts and advocates and individuals with lived experiences. Looking forward to hearing from everyone. Each panelist will have 5 minutes to speak. Please give your name and title, then your testimony. We do have written testimony from everyone, so you don't have to read verbatim. And then each member here has 5 minutes to ask questions in the first round, 3 minutes in the second round. So our first panelist from the Office of Court Administration, the Honorable Judge Rowan D. Wilson, Chief Judge of the State of New York and Court of Appeals, and the Honorable Joseph Zayas, Chief Administrative Judge of the New York State
We can clap
United
for our
Court
judges.
System. Yes. Thank you so much for being here.
Good morning. Thank you for inviting the Unified Court System, which is the way we think of ourselves, not so much the Office of Court Administration, which I try to avoid, to provide written and oral testimony concerning the Treatment Court Expansion Act. Thank you, Chair Fernandez, Senate sponsor Ramos, and Assembly sponsor Soufran Forrest for being here. And Senator Rollison, thank you particularly for being here because the problems that we're trying to address are somewhat different upstate than they are downstate. Problems with geography, problems with different resources. And although you're not deep upstate the way I think of it, it is great to have somebody outside of the New York metro area and somebody with your experience. So thank you for being here. I don't want to repeat what's in the written testimony the court system has submitted. And so instead, one thing we did is append to the testimony a letter that I received in May and a photograph that accompanied it, and I wanted to center my remarks around that. So in May of this year, State Supreme Court Justice Abraham Gurgis, who retired 15 years ago, in 2010, he sat in Kings County. He sent me a letter, and I don't know him. I've never still met him. All I've done is correspond with him. His letter came from out of the blue, and his letter recounted a phone call he got, that he had received a bunch of calls, didn't know what the number was, and so he didn't answer them, but he finally decided to pick up the phone. The person on the phone was a woman who had appeared in his court 16 years earlier. She was charged with narcotic sales, and she'd been selling drugs because she herself was addicted and was selling to support her addiction. So Judge Gurgis, instead of sending her through the normal criminal process, diverted her to a substance abuse program, thinking that in a few months she would get better, recover, and he could sentence her to probation. So that's what he did, but then she started using drugs again. He didn't give up on her. He sent her back a second time, and she again failed. He didn't give up on her. He recognized that addiction is a pretty tough thing to beat, and he sent her back a third time. The third time, she successfully completed the program and returned to court, and he was prepared then to sentence her as promised to probation. And she appeared in front of him and asked to approach the bench. And she said, "I'm not ready, Judge. You're the only one who is watching over me." And she asked to be returned to the program, which he then did and deferred the sentencing. So she came back again, her fourth time, and again asked to approach the bench. And she handed Justice Gurgis a small photograph of her young son. On the back, her son had written, "Thank you for saving my mommy life." He sentenced her to 5 years of probation and didn't hear from her again until the phone call I mentioned. But all those years, he saved the photograph with a little inscription on the back. So 16 years later, which is this last spring, he picked up the phone. The caller identified herself as that woman. She thanked Judge Gurgis for continually putting her back into the program until she was ready to live freely, safely, and productively. She is drug-free, she is married, she has a young daughter, and she owns a home upstate. Her son in the photograph is doing well. So I hope you will take away 2 points from this story, and there are lots of stories like this. First, many troubled young people who harm themselves and harm others had no one in their lives to watch over them. It's unfortunate, it's truly sad that a court might be the only place where a young person can find someone who cares, but that's all the more reason why courts must care. Second, we can never be sure what would have happened had this woman been sentenced to prison instead of treatment. But we can make a good guess that her life would have been worse, her son's life would have been worse, her daughter never would have been born, and the ripple effects would have made the rest of us worse, and we would have paid more to incarcerate her than to treat her. We can be sure of a few things. She stopped selling drugs. Justice Gurgis was overjoyed that he'd saved a life, or two, or more. And we can all be uplifted by the possibility of building a system that affords more people and their families happy outcomes. Justice Gurgis closed his letter to me with the following: I am concerned that the public thinks that all judges do is to incarcerate criminals. They don't understand that sometimes we can make a difference in the lives of those less fortunate than ourselves. That's all we're asking you to do, to help us make more of a difference. Thank you again for inviting us. Chief Administrative Judge Zayas has a few opening remarks, after which he and I are here to answer whatever questions you may have. Thank you.
Well, good afternoon, everyone. It is a absolute pleasure to be here. I want to thank Majority Leader Andrea Stewart-Cousins, of course, the committee chair, Senator Natalia Fernandez, and the sponsor of the Treatment Court Expansion Act, Senator Jessica Ramos from my home borough of Queens, for bringing us together today to discuss this important piece of legislation. And I thank Senator Robert Rollison for his being here today, and congrats on your grandson. We have 5 grandkids, and we don't even want to see our kids anymore. We just say, bring the grandkids over, but good luck. And certainly also glad that that Assembly Member Farah Safran Forrest, the Assembly sponsor, is here. I have to tell you that I have really appreciated the willingness of both the sponsors and their staffs to collaborate with us, my team, to meet with our treatment court judges and to visit our courtrooms, so that everyone has a shared understanding of how treatment courts work and how the legislation would impact all interested parties. As Chief Judge Wilson said, we are both here this morning because of the unified court system's firm commitment to the expansion of treatment courts and other problem-solving courts throughout New York State. I don't have to tell you, any of you, that we are in the midst of a mental health crisis. Many New Yorkers are desperately struggling with mental health disorders, substance abuse issues, or both. For too many people, the first opportunity for intervention, unfortunately, comes with an arrest and justice system involvement. And we believe that regardless of whether the intervention happens in Brooklyn or Buffalo, Poughkeepsie, I was going to say Peekskill, but I'm going to change it to Poughkeepsie or Plattsburgh. Our courts should be really ready and willing to help. For me, some of you know this, the importance of connecting people with treatment is personal. My father had a serious mental illness, schizophrenia, and often he would be actively delusional. My brothers and I sometimes had to work with his doctors and the police to get him committed and to get him to connected to services so that he could get back on his medicine. Like other people who have lived with a loved one with mental illness, I understand that if left untreated, my father would do inappropriate and extremely bizarre things. But he wasn't a bad person. And certainly he was not a criminal. He just needed help. I'm sure it's because of my experiences with my father that as a judge and as a former public defender, I've always been committed to figuring out how the courts can help people suffering from mental health and substance abuse issues. In fact, almost 20 years ago, even before the unified court system had a formal process for implementing new problem-solving courts, I started a mental health court in Queens, and I did it on the down low. I had the intuition then that these interventions were a way of being being smart on crime. It's a phrase that a holder from the Obama administration, I'm forgetting his title, what is it?
Attorney General.
Attorney General Holder was fond of using. Being smart on crime, because I think your bill is being smart on crime. If we could effectively address the issues that triggered criminal behavior, we could make our streets safer, reduce recidivism, and improve people's lives. I found that in many cases, this approach also made sense to the victim, who was often the defendant's relative, friend, or neighbor. I don't have much. They thank you. They knew that sometimes people do bad things for reasons that have nothing to do with cruelty or antisocial personality, and that jail was not the best solution. We have come so far in the years since I started mental health court. We now have over 350 problem-solving courts in New York State, including 42 mental health courts, and we serve in 27 counties. A dozen more of these courts, you should know, are in the development stage. Our judges have built these innovative programs by engaging with stakeholders, prosecutors, the defense bar, service providers to help address problems of serious concern to their communities. For these judges, this work is a calling and a passion. Many of the legislators here today have been able to witness the passion and empathy of these judges firsthand in their visits to our courts. In many cases, our judges have sought grants and other funding to make sure their courts are adequately resourced. Some of this financial support has come from the district attorney's offices, who have also been increasingly committed to diversion because they know it works and that it increases public safety. In our review of the Treatment Court Expansion Act, we have drawn heavily upon the collective wisdom of our problem-solving judges, court judges. Their experience has taught them what works in these challenging cases. They know how to get someone who has failed at treatment, sometimes more than once, twice, and 3 times, to finally succeed. Our judges work in this area also know what I hope all of you can appreciate, which is that diverting defendants with mental health and substance abuse issues, particularly those who have been charged with serious crimes, is not for the faint of heart. It takes real courage. There are inherent risks to this work that no one can eliminate. No matter how carefully we evaluate needs, choose appropriate programming, and monitor progress. The proposed changes we have outlined in our written statement are motivated, we want you to know, by a desire to meaningfully expand our treatment courts in a responsible and sustainable way, and in a manner that will hopefully preserve much of the collaborative approach that is a foundational element of the problem-solving court model. So thank you again for convening this hearing and for your interest in expanding the court's ability to change lives and make communities safe. The Chief Judge and I, as he said, are happy to answer any questions you might have.
Thank you so much. I'll defer to our senator to answer or ask the first round of questions.
Well, thank you, Senator Fernandez. First, let me say that in my 7 years of participating in hearings as a senator, I had never seen the state agency be clapped up to testifying. And let that be a sign of hope. And understand the hope we have in each one of you, that we believe in you as true reformers, and that we can inch closer to actually getting it right. And thank you, Judge Zayas. I can't imagine that it must be easy to speak about your personal experience, but mental illness does impact each and every one of us, first and foremost, I want to ask, how much do you guys think this is going to cost? For us to do it right, for us to do it sustainably, how many more resources is your division going to need in order to expand the way we need to?
So let me take a stab at that. And the first thing I should say is that in the long run, this will actually save the public money, because the cost of incarcerating people as compared to the cost of full-blown treatment, it's much more costly to incarcerate people. Now, will there be upfront costs? Yes. Those costs and I should break those into two parts. The costs for the court system, I think, will be relatively modest. We'll need a few more judges here and there. We'll need other court personnel, to people who help place people in different areas. But those are going to be relatively modest, I think, startup costs compared to what's really needed, which is outside providers to provide the services. There are places in the state where those really don't exist at all. And some of those are places where the population is fairly sparse, the geography is big. So the bigger challenge, I think, for you on your end is not going to be so much funding the courts, but creating the outside infrastructure necessary to provide the treatment. And in our testimony, I think we try to make this clear that, and this also affects the budgeting question, if you pass the act, at least the way we're envisioning it, it's not that all of a sudden, miraculously, there's going to be treatment everywhere. It's a slow ramp-up process as the outside resources get built, and part of what we are hoping for is that the chief administrative judge will have the ability to say, okay, now we can start an extra treatment court here because the resources are available. So it's a slow ramp-up.
Okay, so you're not going to give me a number.
No.
But I am hoping that by the time budget rolls around, because I do imagine we will need some extra resources, that we can expect a much more formal budget ask from you.
Absolutely.
Thank you. I also want to ask, in other criminal justice reforms, many times the legislature ends up making categorical decisions about eligibility for different things, but it's something that we actually refrain to do in our bill. We really defer to judges to make those calls. In your experience, do you think judges are able to make assessments about a person's suitability for diversion, including their public safety risk, without a statute that enumerates which charges can be considered and which cannot?
So I think yes, but let me qualify that with two things and then turn this over to Judge Zayas a little bit so he gets a chance to say something. One is that not every person and not every judge is suitable for this kind of work. So partly we have to be careful about whom we pick for these. The second is people need training, including judges. So yes, the right person with the right training can do this without that kind of guideline, but not every person can.
Yeah, and I take it your question was more related to the potential participants in the program. And I do have full confidence that judges are able to make these distinctions based on all of the factors that might be before them, including past records, past treatment efforts, right? A lot of times folks will come before the treatment court judge who had already failed treatment several times. And so there are so many factors to consider that I think judges are fully capable of making those determinations. As the Chief Judge said, we put judges in there that are particularly sensitive to these things and have the training to do these things, and I think the judges are fully capable of doing that.
Thank you. Thank you so much. Becca, would you like to go next? No? Okay. All right, well, thank you again. I was really touched by that story in the beginning because that was a judge that truly cared. And you emphasized in your testimony earlier about the individualized attention that everybody needs because we know that everyone has a different story, different needs. And maybe you did just mention this, but how do you ensure equitable outcomes to avoid disparities between county, within the state, judges and programs that are available around the state?
Yeah, I mean, I think that's one of the highlights of the statute of the Expansion Act, that it does try to create a more same approach across the state in terms of the, and especially if you think about the amendments or the changes that we proposed, that, but there will always be in our state, because of different tendencies, political tendencies, views on public safety, et cetera, there might be some divergence. That doesn't mean that the program has to be different in every county, but there might be some judges upstate, being frank with you, and other places, but also in New York City, who might not feel comfortable taking a plea in a particular case where some grave violence, some grave harm was committed, allegedly. So there might be some difference based on I think the nature of the alleged crime than the judges.
So some cases would require a plea to be determined?
Yes, I mean, as you know, in our written submission, we think that post-plea has to be on the table, because if it's not on the table, there's going to be a lot of judges who are going to not are going to reject the opportunity to give a person a chance at the diversion. That doesn't mean that all of those cases have to be post-plea. There can be pre-plea cases, and that's perfectly fine. And given the judge's discretion and the judge's knowledge and the nuances of the case, so every case is different. But especially for violent felony offenses, when a judge is considering that, the evidence shows that when someone takes a plea, they feel, at least, especially in the beginning, that they need that, and it shows that when you take a plea, more defendants wind up succeeding in their treatment plan.
Interesting point, okay.
Let me add a couple of things to that.
Please.
One is that if you think about equity, there are 62 counties in the state, 27 of them have treatment courts. So there's a staggering lack of equity simply that we can't provide the treatment to most of the counties in the state. The other point to add about the pre-plea is that there's also the option for a court, even if somebody takes a plea, after successful treatment, to vacate the plea, right? And to go forward with nothing. So these all have to be highly tailored. And that's, we have to trust the judges to be able to do that. Our treatment court judges tell us there really are many people, not the majority, but many people, who need to have a plea as motivation, which is what Judge Zayas was saying.
Okay. No, that's a fair statement. Alrighty. My next question, let me just go through my list that I had prepared here. So the legislation was amended this year to allow judges the ability to consider the availability of treatment services in their communities when they are deciding whether to admit somebody. Do you think that this will help courts manage the influx and adjust capacity as the community-based services come online?
Yes, of course, the most important thing is to have the services available in the community. This, as Judge Zayas mentioned in his opening remarks, there are going to be errors, right? People are human, so even judges are human, and sometimes a treatment program isn't going to work, and somebody who's on a treatment program has been diverted is going to do something else bad and hurt somebody else. But to avoid this being a failure, the way to make it a failure is to divert people and not have anywhere to send them. Then you're just sending untreated people with problems with no supervision back on the street. We want this to succeed, and to be able to succeed, you've got to have programs to send people to.
And just if I could add to that, one of the proposals that we've made is that there will be a gradual implementation of the program, and that would allow us to make sure that the places that always happens only when I talk, not when he talks.
It's because I'm watching you talking or not.
But I think that the proposal gives the chief administrative judge the obligation to certify that certain counties, probably the more rural counties, have the necessary infrastructure, services, programs. One of the things with that we've always been worried with this is we feel like we can get our act together completely and be ready for this. But we are concerned, and this is where we think a lot of the money needs to be devoted to making sure that the defendants that we send to these programs are able to go to a program. So we're concerned
That is
that
near
the
home.
funding, what's that?
That's
Yeah,
near
that's
home.
yeah.
Yes, that's right. So that we're an equal effort, or maybe even an extra effort, has to be made to make sure that there's funding for the programs to which we send these defendants. We're going to get our act together, but we also need to have funding for the places that we send our defendants to.
I'll be sure to work on that this year, too. Thank you. Senator, any questions?
Yeah, thank you. And then it's good to see, of course, both of you here. And I want to just kind of follow up on some of the things, that, of course, that my colleagues said. When we talk about violent felonies and then lesser felony charges with the plea arrangements, right? And I think, Judge, that you had said, and of course both of you, that certain judges are going to want to plea on certain cases to then sort of have whatever, I guess, that carrot and stick approach, that you have the opportunity to go into treatment, and then once that takes place and you're successful, then we can talk about whether it's vacating, whatever else can be done to give that person the best chance at moving forward. But are there going to be times that straight up within the statute that you will not plea, you do not have to plea? Is that an accurate statement?
Yes.
Yeah.
Yes.
So there really isn't a judicial discretion on whether as a judge, I want you to plea. In certain cases, you will not have to plea if prior to going?
No, I'm sorry. No, that would be up to the judge also.
Okay.
Right. That would be individualized.
And what is the role of the district attorney in these possible movement into the treatment side of the criminal justice system? Do they have any say in this based on the charges and their involvement, or is that outside of the DA's purview?
I mean, I think they have an absolute say, and their views they have a right to give input. I think that's the types of things that the judges will consider in determining whether or not this is an appropriate case for. The whole treatment court model is based on collaboration between the judge, district attorney, and the defense attorney and the providers, and we expect that would be the case going forward. That is the plan. Now, you're asking, I think, a little more specific question. Maybe I'm inferring from it that will the prosecutor have the ability to veto the pleas? And there are certain offenses that are already taken out of the equation, but the prosecutors would not have that right. But certainly their views, their powers of persuasion, their reasons for indicating publicly that this is not an appropriate case can be expressed freely.
And I would imagine, though I don't know this specifically, when a judge is going to make a determination on diverting, whether the DA weighs in positively or feels that it is not eligible for diversion based on the crime charged, I would hope, and again, take what your thoughts are on the crime victim. Not every crime victim is probably going to be supportive of this particular diversion based on what happened to them. And I think that that's really important because obviously we know that the victims, unfortunately, stay victims generally for life. That being a crime victim can be the loneliest place in the world.
So
And
let me, if
yeah.
I can interrupt you for a second, I'm sorry, but let me add
Yeah,
a
thank
couple
you.
of things. So there is research showing that when the DA is involved and is supportive, the whole process is much more successful. The rehabilitation is more successful. The treatment is more successful. So that's very important. And the Brooklyn DA's office, so I don't have information beyond that, has said that 85% of the time they get the victims to agree to diversion. So that's a pretty big number, and I would assume that's replicatable.
Yeah, because, I mean, obviously, the empowerment of the victim is important to their healing. And also, the diversion can be important to the healing of the individual who has been charged. And I think that is really an important, part of this process. And just real quickly, as a follow-up, and talking about where, in the Hudson Valley, we have these types of courts. Upstate, probably not as many. And if the county wants to do it, but doesn't have the available funds, and I know my colleague had mentioned this, on a funding ask from OCA to the state legislature to say, if we want this to be successful, because just because it happens in Brooklyn County doesn't mean and diverted in Brooklyn, it should be diverted in Chemung and other types of more rural counties in upstate. And I could see that being a challenge. So I think, as that budget process unfolds, really having the ability to say, we believe that this is the type of money that would be required to do this. And then again, and I'll end with this, and then on the treatment side, we know treatment is more robust and more available and more suburban and metropolitan areas than when you get to the rural areas. There are all kinds of deserts, including treatment deserts.
Right, that's why we're recommending a gradual implementation where we can assess and build up the infrastructure to handle that.
Thank you both.
Assemblyman Forrest?
Thank you so much. Judge Zayas said a magical word in my brain, which is the assess word, because as a nurse, before we can even think about solutions and plans, we have to assess. And to really illustrate why we took every feedback seriously, when you say, okay, wait, where are the services? One of the things that we said we made sure we put in the bill is to allow a live feedback. VARA or the legislature, this is what we were able to accomplish because this was here. This is where this person went, this is where this person went, because this treatment option was available. Here's who wasn't able to go, and this is probably because they weren't able to get this treatment option. Because one of the things that I love with all my colleagues is that the resources of the state is for all. It's very bipartisan, these dollars. And so if a legislator says Oneonta needs, okay, Peekskill needs, Poughkeepsie needs, then they're allowed to say, we need it, you should get it, just like Brooklyn gets it too, right? Because my saying is, closed mouths don't get fed, right? And this is what I love about this bill. A lot of mouths are opening up and saying across the state, we need these resources. It don't matter what the religion is. We want it to be culturally competent. We want it to be culturally sensitive. But we have to have that mechanism to report back. So I'm so glad that OCA and the sponsors of the bill was on point on that one. But I do have a question, though. Judge Zayas, you mentioned that you have 42 courts going with staffing on a DL budget, okay? So,
On a what type of budget?
down low budget, right?
Oh.
And so what we're asking, one of the first questions is, can we expect an official request for at least the OCA side of this, right? How much do you need to open up at least one on the shoestring budget?
I gave you that number, and I also added that there are 12 other mental health courts in development. So, before we know it, we're going to have, what's 27 and 12? 39? Yeah. All right, there we go. We have 42 already, and then 12, right. So
Nurses aren't good with
the real issue is there are just some counties that have, and I'm trying to get around the state as much as I can as the statewide chief administrative judge, and but there's just some counties that are so tiny and so rural. They're just, I'm almost afraid to say this, but they may not have a need, and so we don't want to invest resources in a county that has, 300 people, 600 people. And we would try to, and it would be maybe not cost-effective to put a court in a place like that. So, the idea of getting to all the counties is a good one, but there are just some counties where we have to look at, and that's why we think the gradual implementation will solve that problem, because we can do a study when we get to those counties and make a determination as to whether or not it might be. And we're exploring a lot of different things of whether or not another county, which would then require people to travel long distances, et cetera. So we're trying to work through all of that.
So I always say that this bill is not a new thing. It's working on a precedence of drug courts being established in 2009. Can you talk a little bit more about how drug courts have been working in the past, and to kind of illustrate what we're building on?
Sure. So it's a very interesting thing. My experience is mostly in the city, New York City. And, the diversion court, CPL 216, is not the primary place where drug treatment cases and other cases are being used. It's in the mental health courts, it's in the veteran courts, it's in the ATI courts that I know you visited in Manhattan. See? That's why he gave me the question, because he knew there was 30 seconds left. So we are thinking a lot about that, like what effect would the implementation of this have on a court in Manhattan, the court I think that some of you visited, and Senator Fernandez, you visited some courts in the Bronx, I know as well, some mental health courts. We do not expect those courts to disappear. I mean, they are doing a great job. The ATI court in Manhattan that Judge Bybin presides over, that court's been doing an extraordinary job. And it's been interesting to me that the courts, the diversion courts, have been the courts that have not had the high inventory. The ATI court in Manhattan, for example, had probably the double or triple the inventory of the diversion court.
Senator Fernandez, with your permission, may I?
Permission, 30 seconds.
So this relates to your to Assembly Member Front Forest's earlier question. So there are plenty of people in the state with mental health issues and substance issues who are not criminal justice involved. Those people need help as well. And so when we're thinking about resources that can treat those people, that are also resources that when there are criminal justice involved people we can send them to, the fact that you're talking about Chemung County doesn't mean that there aren't people there who are not criminal justice involved who need help. This goes back to 2024, I think, in the governor's State of the State address and in the budget, she announced $1 billion generally for mental health. And I'm not exactly sure what happened to that money, but it should be there. It should be distributed throughout the state, and it is resources that we can divert people to, even if the bulk of that is not being spent on criminal justice involved people.
Yes.
Thank you for bringing that up.
Thank you.
We should check in on that money. We should.
We don't have any of it.
No, adding to our to-do list. But Senator Ramos, you wanted to come around again?
I did. And I actually wanted to start with a point of information for those watching at home, because the Treatment Court Expansion Act offers a bifurcated pre-plea model that would allow judges to require upfront guilty pleas for people charged with violent felonies, but it also allows those facing nonviolent felony charges and misdemeanors to enter these programs immediately without having to plead guilty. So I just wanted to offer that clarification, and I also wanted to shout out the New York Health Act, which is another mighty bill being carried in the legislature that would allow New Yorkers to be able to access all sorts of health resources both physical and mental, and that should be able to help those who have not committed a crime. I want to give you the remaining time, gentlemen, to talk about the Task Force on Mental Illness that you convened and that produced a report that you released this past February, where you are precisely talking about establishing regional mental health courts. What would be the process of adopting these? Are there any aspects of our bill that are being considered as you're undergoing this expansion, and what should we look out for?
See, there's
You've got plenty-
there's
you've got
no
plenty of
time left.
I'm giving you the whole time.
So it really, what the Mental Health Task Force recommended aligns perfectly with what we had already been doing. So the $8 million that we received in 2024's budget was completely devoted to, and that, when I mentioned earlier, there's 12 mental health courts in development. A lot of that money went to that and to beef up the mental health treatment courts that we already have, so that they can expand their inventory. And so that is exactly that. That recommendation, that particular recommendation, is precisely related to what we're.
Have you chosen regions already? Where will those 12 be?
I would have to get back to you on that particular question. Yeah.
Nothing to add so that the clock can stop you, Judge Wilson?
No, I could fit in under 30 seconds. The bill would allow us to, so the recommendations of the task force, I think, are completely in line with what you're trying to do through this legislation. The legislation, when it is fully implemented, allows us to divert many more people.
Thank you.
Anybody else?
All right.
I do have one question.
Okay, well, you got 3 minutes to follow up. I just want to ask one question, too.
Oh, no, cool.
Yeah, okay.
Yeah, no,
All right, so we'll end this now with 10 seconds. Thanks. So, yes, thank you for bringing up my visits and conversations with the Bronx treatment courts. Shout out to Judge Lee, because it was beautiful to see how much is really tried there with the local organizations to each individual case. And going back to the money, I know a big need is just having the resources to stay connected to many people. So as much as, people want to criticize, oh, you're giving them a phone. Well, if the judge is the only person that cares, how are we going to keep in touch with this individual to make sure that they're following up with their needs? But one thing that was mentioned in Oasis's testimony this morning was the disparities that exist between Black and Brown and Hispanic communities. Do you believe that the Treatment Court Expansion Act will help reduce this disparity? I'm sorry, let me clarify a little bit. There is a smaller decline in justice involvement for those with a substance use disorder among Black and Brown Hispanic communities compared to white communities. How can this bill help change that?
Well, it's actually the other part of it that is the funding for the treatment programs that can be more robust. That's what will actually make a difference. I mean, of course, it's important to catch the people, but it's really the robustness of the treatment programs that will make the difference there, I think.
Knowing where we need to put the money, right?
Yeah.
Thank you. But that is something that I think we should continue to look into in the next session and moving forward, why these disparities exist.
Because part
and
of it is
how
a wealth
to-
disparity, right?
Yeah.
And so, if you're middle class or relatively well off, that tends white, right? And those people can access private resources. They have health insurance. They have other things that poorer people don't have. If you can make, and this is not so much the court system now, this is the other
No, it's the
resources. If you
resources,
can make
yeah.
those more robust, that's how you can attack that difference.
Thank you for putting that on the record. Assemblymember Forrest?
So, Chief Justice Wilson, during your 2024 State of the State judiciary speech, you said that we should think of courts as problem solvers, not solely as adjudicators of which party is right. And then you quoted Helen Keller and said, the heresy of one age becomes the orthodoxy of the next. Can you expand on that? Like, what do you
I'm
mean
sure you
by
want me
that?
to. Well, sure. I mean, if you think back 1,000 years or so, somebody committed certain types of crimes. You chop their head off and put it on a stake. And the thought was that that would deter other people from doing that. That didn't work. And no one now, I think, would think that that's a reasonable thing to do. The criminal justice system that we have inherited has improved over the last 1,000 years, over the last 100 years, but it's going to be better 100 years from now. And it's important to understand that what we have now is not perfect, and that, we started out talking about evidence-based things. There is a lot of evidence that treating people instead of incarcerating them provides better results for them, provides better results for all of us, both in terms of saving taxpayer dollars, but more importantly, keeping everybody safe. And I don't think there's anybody who would say that they would rather have the community be less safe than more, but the system that we have now is doing just that.
And I'm at a nursing conference yesterday, and one researcher said, I am not married to any procedure. I am not loyal to the procedure. I'm loyal to my practice, though, my code of ethics. And so to have if I said, oh, we still leach bodies because we think that you get impurities out the blood by putting leeches on the body, you would think that's insane. But that was medicine in the 1800s. And that was real. But now we know evidence-based practice.
Let me make one other point, which is that, and I was yesterday speaking just in front of Justice Breyer at something, and I've heard him make this point a couple of times, or tell the story a couple of times, that when he was counsel to the Senate Judiciary Committee and Senator Kennedy was the chair, Senator Kennedy said, when you get into a disagreement with somebody on the other side, talk about it and take 30% of what you want. So it's worth experimenting. We're a big state. We can try different things, different places, and not everybody has to a priori agree this is what's going to work. We don't know that. So let's try different things, different places. See what works, and the same thing may not work in the same place, right? May not work the same way, but that's not a reason to stick with what we've got. 1 second left.
Good job. All right, Senator Rollinson, for your follow-up.
Yep, thank you. In coming to the legislature in 2023, there was a lot of discussions, and remember we had the hearing on data as it relates to the criminal justice system, and there was dispute between members of the legislature, municipal officials, state agencies on data collection. OCA had this, DCJS had that, and really the systems weren't talking to each other. So clearly there's a challenge there, and I think the purpose of that particular hearing was on data on crime statistics, right? Is there going to be data collection if this program is implemented and in the counties that have these courts and actually that have them now, that would be able to say, when we talk about who reoffends, would a plea have been more appropriate because if the person had pled, they probably would have stayed, in the program. So is there, because the last thing that we want to do is have those discussions again about something that may be implemented that can be successful in some areas and need to be maybe reworked in others.
The 2023 discussion was before our administration. That was meant as a joke. Come on. That was before.
So maybe it was 2024 then, but
no,
you weren't part of that. I know you weren't.
Yes.
But there really was, and not to belabor it.
I get your point.
There was a lot of people that just didn't know.
Right, but with respect to our data collection in treatment courts, it's robust. It's used. The success rates are easy to discern. It's not perfect, and we have some work to do in it. But our technology division is really all over this. And when this passes, we'll make sure that there's data that can evidence-based data that will let us know the success rates and the folks who failed and other maybe factors that contributed to the failure, et cetera.
But it's not a joke that we inherited some serious data collection problems. I mean, you know, it is a little bit a different subject, but for family court, what we learned is it turns out that in some places we count a family as a case, other places we count each child in the family as a case. And so when you're trying to reconcile data and say, well, where do you need more family court judges or more resources, when you're using different metrics,
Yeah.
you know.
Yeah, we had that family court hearing in this very room,
Yeah.
and a lot of those things came out. And just one other thing, I'll end with this, is that when someone does not complete the treatment, and now the option will be to prosecute that person, there are some folks who would say that, you know, you're going right back to sort of square one when you don't have the plea. And I would hope that would be something also that we would be able to say, is that taxing on the district attorney now to reopen a case that could be, you know, and I don't know the time frame, but it could be maybe a couple of years. And then how do you do that if you have to go right back, and then also giving, you know, the power to the victim 2 years down the road? So just a thought.
We've recognized that in our written testimony, actually, that is an issue.
Thank you. I appreciate
And
that.
I'm not sure that when someone takes a pre-plea, that the district attorney's office has to shut down their investigation, or, you know, there could be an arrangement where a defendant gets into treatment, gets diverted with a pre-plea, and then the district attorney is complying with discovery, et cetera, you know, so that the problem of the prosecutor losing witnesses, et cetera, is mitigated.
In a pre-plea.
Yeah, in a
Absolutely.
pre-plea
Yeah.
situation,
Right.
so.
Yes. Thank you, Judge.
All right, thank you. I think that completes our first panel. Truly appreciate you being here. Please enjoy the rest of the panel. Our next panelist will be, is this the correct one? Yes, okay. Selwyn Bernardes, Nicole D'Alessandro, and Ashley Santiago. Yes, okay. All right. May everybody please introduce themselves, your name and your title, and what org you're from?
Good morning.
You could bring it closer.
Good morning, everyone. I am Selwyn Bernardes, and you can pretty much call me an activist at this point. Yes.
Good morning. My name is Nicole D'Alessandro. I'm a peer specialist for cases, New Start.
Hi, good morning. My name is Ashley Santiago. I'm the senior community organizer at Freedom Agenda.
Great. Okay, Selwyn, you can begin. You have 5 minutes.
Good morning, esteemed members of the New York State Senate plus Assembly. Thank you for holding this important hearing on urgent needs to pass the Treatment Court Inspection Act, a transformative piece of legislation that would give far more New Yorkers who really just need mental health support and healing the chance to participate in such a program instead of jail or prison. My story began in the fall of 2022. At the time, I was in a crisis. My mom was dying of leukemia, an excruciating, painful process for all her children, but especially for me, her favorite. She went into a coma days after surgery for a bone marrow transplant and sadly never woke up. Seeing her in that hospital, laying helplessly, hooked up to tubes and machines, triggered a serious mental health spiral. 2 weeks before she died, I checked myself into a psychiatric hospital for what would later be diagnosed as a grief-induced psychosis. I was held there for about a week, and within a few days of being released, I got a call that my mother had passed away. Days that followed are a blur. I went back to my apartment and in a drug and psychosis-induced rage, destroyed everything. Eventually, I started roaming the streets and subway systems with a samurai sword, a katana which was a gift to me from my mother, a horrible, beautiful gift. On the subway platform at the Chamber Street station, I encountered a panhandler who I perceived as acting very aggressively towards me. We ended up fighting, and I hit him with the sheath of my sword. I was arrested and charged with felony assault. The next day was my mother's funeral, but instead of grieving with my family and saying goodbye, I appeared before my arraignment, where the judge set bail and sent me to jail. I spent the next 6 months at Rikers Island. I was already going through hell, but this was hell on earth. My mom sent an angel to me. Her name is Gabriela Mejia, a public defender assigned to my case. She understood that I needed treatment, not jail, and she spent the months that followed fighting like hell to get me that treatment. Eventually, she convinced the prosecutor and judge to let me into the felony ATI, Alternative to Incarceration Court, a diversion program. This was the beginning of a new chapter. I spent a year doing intensive programming, therapy 3 times a week, weekly groups therapy, AA and NA meetings, etc., and regularly checking in with the court. The treatment provider staff and the case managers were so kind and warm to me and gave me a safe space to process the trauma I just lived through. By the end of 2023, I started working again, pursuing personal training and acting. I made new friends and restored my relationships with my siblings and other family members. I became close with other participants in the ATI program as well. In June 2024, I officially graduated from the program. My charges was dismissed and my case was closed. It's been over a year since I left the ATI program, and I have never been stronger. My story was profiled by the New York Times, which gave me the chance to reclaim the salacious narrative of this experience. My acting career has taken off, psych. I have a thriving personal training business, not super thriving, but I'm doing something. I am closer than ever with my family, and I still keep in touch with the amazing Gabriela Mejia and the treatment program who helped me. Now I also have the chance to give back. I do services and I advocate for the policies that could give more people the opportunity I had. The Treatment Court Expansion Act would do that. My path is not the norm, but it should be. I improved that mental health and substance use crisis are treatable, and Treatment Court program teaches us the skills we never had to manage our ongoing mental health struggles. Incarceration only teaches recidivism. We must eliminate every barrier to accessing these crucial life-saving services. And I'm ending just like this. I was in North Carolina over the summer, and my little sister, it happened to me, oh my God. All right. I was in North Carolina over the summer, and my little sister is a splitting image of my mom. And I was sad to leave, but she told me this. She's like, brother, faith made things possible, not easy. And that's it.
Right. No, thank you. Thank you. Nicole?
Good morning. Treatment court has been nothing but helpful for me. Without treatment court, I would not be in the place I am today. Before I had the opportunity to participate in treatment court, I was in a bad place. I was struggling with mental health and active addiction. I was dealing with domestic violence, and I was dealing with neglect and homelessness. Dealing with my active addiction was difficult, but I turned to committing burglaries just to get by. I obviously wasn't in a healthy state of mind, and I wasn't in a healthy physical condition either. I ended up getting arrested after months of living like this and ended up in jail. Originally, after remanding me and being incarcerated, I concluded that I didn't want to live like this anymore, but I didn't know how to change on my own, and I needed help. I got lucky and I qualified for the electronic monitoring program to begin my mission for change. After being released to house arrest, I got the opportunity to start drug court. At drug court, they recognized my hardships that I was dealing with at the time, and they recognized my want for change. They were the help I needed to get my life on track. I didn't need to be incarcerated. I needed assistance with my mental health and my active addiction. Through treatment court, they were able to get me into a detox program and then a residential treatment program to begin my journey to recovery. While in the residential treatment program, I got the mental health assistance I needed as well. I got medication to assist with the psychotherapy I was receiving through the program. The treatment court also helped me come up with a treatment plan that followed the mandate guidelines while continuing to help me with my needs at the time. They also helped me to work through my goals and ideals that I had for my future. While in residential treatment, I was able to start working towards my dream job and start training to work towards that dream. After the residential treatment program, treatment court was able to set me up with a reintegration housing program. At that program, I was able to start working towards my dream job as a peer specialist to use my experiences to do good for others. To conclude, without treatment court giving me a chance and recognizing my needs and recognizing that I needed help, not incarceration, I wouldn't have succeeded and gotten as far as I have come today. I just want to give a big thanks to the people and the judges that were part of my journey in treatment court, and I want to give them a huge thanks for giving me the chance that I deserved. The legislature should definitely pass the Treatment Court Expansion Act so everybody can have access to treatment court just like I did.
Thank you. Ashley?
Thank you. Good morning, committee members. I submit this testimony in strong support of the Treatment Court Expansion Act, and I thank you so much for hosting this hearing this morning. Again, my name is Ashley Santiago. I am the senior community organizer with Freedom Agenda and also the aunt of a young man who has several mental health diagnoses and developmental challenges. He has been incarcerated for the past 4.5 years. He's on Rikers Island and in multiple state prisons. His experience sadly highlights the failures of our current treatment court landscape, in which people without any clinical experience hold far too much power in determining who can access treatment, and in their ignorance shut the door on far too many people like my nephew, for whom intensive treatment could have been the most important intervention in preventing future court involvement. My nephew is close to me in age, so we grew up more like siblings. He has an array of challenges. He has a diagnosis of disruptive mood dysregulation disorder, and he's also on the autism spectrum, and operates on borderline intellectual functioning. Because of this, his lawyer requested him to be evaluated when he faced charges in Queens County. We provided the Queens ADA on this case and the judge with his mental health records from 5 different mental health facilities. And after reviewing all his records, the ADA denied him an evaluation, stating that she finds he doesn't have behavioral problems, he has tantrums when he does not get his way. After writing directly to DA Katz and reminding her of her prior statements in support of treatment diversion, my nephew was actually referred to task for an evaluation, which was completed by a psychiatrist, Dr. Fernandez. Dr. Fernandez highlighted the severity of his impairments and his need for treatment. Contrary to the ADA's non-clinical interpretation of my nephew's records, he stated, due to his diagnosis of autism spectrum disorder, my nephew does not fully comprehend the implications of his behaviors. Dr. Fernandez and my nephew's care coordinator with the Office of People with Developmental Disabilities, OPWDD, discussed locating residential programs with specific services to rehabilitate him. Dr. Fernandez also indicated that my nephew would have a chance of success by receiving specific treatment and interventions with his disorder and cognitive disabilities taken into consideration. His care coordinator even met with alternative sentencing director Douglas Knight in the Queens DA's office to further discuss the matter and started working on finding a restricted residential facility. However, during my nephew's court hearing, Mr. Knight stated because OPWDD had not yet found a placement, he was ineligible, and the ADA suggested sentence of 6 years. The ADA also mentioned that she was never actually considering treatment, but only gave my nephew a clinical eval at the courtesy of his mother, my sister. The judge scheduled a meeting in her chambers, including the ADA, Mr. Knight, clinical staff from OPWDD, and my nephew's attorney. And then again, at the time, that's when the ADA stated she was never considering mental health treatment. The ADA then proceeded to take pieces out of the assessment to criminalize my nephew. His impairments are due to an illness and should not be used to dehumanize him. The law currently gives prosecutors the right to disregard the findings of mental health professionals, which undermines both public health and community safety. The daily dehumanization of Rikers, along with the grueling trips to court, wore my nephew down, and he eventually just took a plea deal. And his time in New York State prison system has included aggression from officers, multiple stints in solitary. I would say that the entire time my nephew has been incarcerated has mostly been in solitary confinement, and months without programming or regular recreation. But predictably, also no substantial treatment. I know would have given my nephew the stability he needed to be at his best. He needed intensive quality treatment. Instead, he got in years of neglect, abuse, requiring him to be transported to emergency rooms 3 times. As we prepare for his return home, my family has faced the reality that trauma of prison has now added to his mental health challenges, including his time in solitary, which his counselor has shown to show onset signs of schizophrenia because of his time. We will need to help him cope with all of this. We are grateful again to the Senate for holding this hearing, and we need you to take the next steps with your colleagues to ensure that the Treatment Court Expansion Act passes in the next legislative session. Decades of criminalizing mental illness has brought New York State to a crisis point, and we can no longer wait any longer to expand the pathways to healing and safety that the Treatment Court Expansion Act offers. Thank you.
Thank you all so much for being here and for sharing your stories. We can see and know that it was not an easy experience, but I really do thank you for sharing it and helping us see what others don't see. Mr. Selwyn, you did spend some time in Rikers, and I don't want to bring up too much pain, but can you detail about how Rikers was or was not helpful to you in terms of if you sought mental health support and what they did, how they did it?
Well, everything on Rikers Island is delayed. You know, it took me months to see a therapist. It was like the worst experience of my life, to be honest.
How long were you there in total?
6 months. And my lawyer was putting in the work. Like, you know, she was, are you seeing a therapist? Are you getting your medication? Like, she was like on it, you know. And at the time, like, she was like my guardian angel. Like, you know, like my mom, like, I don't know, just like the experience I have with this lady really like shifted my whole perspective on, like, you know, on life, you know. And like it's painful to think about it, but it's just like I'm also super grateful for it too, because it's like I have a community now. I have friends that literally became like family to me, all through the death of my mom, you know. And I'm a firm believer of like you can't destroy energy, you know. Like my mom's energy and spirit is still here with me today. I feel her every morning when I wake up and pray. Give me the strength, you know. And I truly miss her every day. And losing her was a blessing in disguise, you know. So I just want to thank God for everything, and thank you for the opportunity for me to share my story with everyone here. You know, life ain't easy, but I do my best every day. I put my best foot forward every day. I'm not perfect, but I do my best every day. So I don't recommend Rikers Island for anyone, not at all. And just me here thinking about it just like brings up crazy memories, you know, because I'm in there fighting for my life, literally fighting for my life. Food is horrible, inhumane conditions. CEOs treat you like crap. They don't care. Like, I wouldn't want that for my worst enemy. You understand? So I'm just happy that I'm not in there no more. Like, I'm out here. Like, I'm following my dreams. I'm doing what I got to do. Like, I'm still going to meetings to this day. Like, still programming to this day. You know, because, like, it
Recovery's
works.
forever.
It's like, it is, and it really works. It works for me, and I know it can work for others, too. Just got to find something in it and just go for it.
Thank you. Ms. Santiago, you mentioned how it was found that the time in incarceration made your nephew's situation worse. How long did it take to get to, well, maybe not how long did it take, but could you just describe a little more about what had worsened his condition and when that realization came to, and what was his suggested treatment after?
So my nephew still upstate, unfortunately. And I think, well, not I think, I know what actually added to his time is the fact that my nephew's entire time incarcerated has mostly been spent in solitary confinement because of his severe mental illness and intellectual disabilities. Correctional officers often don't know to notice when someone is in psychosis or in a state, so it becomes a behavioral issue where my nephew has spent 23 hours in a cell a day with 1 hour outside of cells time. So over time, around maybe within the last year, we would get phone calls from him where my nephew started showing severe signs of just paranoia. He could say that he could hear other people's thoughts with his time alone in the cell. And then it wasn't until his actual counselor at the prison was letting us know that they are starting to see signs of onset schizophrenia.
Terrible. All right, I think that's it from my round, but thank you so much. I pass it to anyone here?
Yeah,
Senator
sure. Thank you,
Ramos?
Senator. Selwyn, I want to begin with you. I want to learn a little more about your guardian angel, Gabriela Mejia. And I mean, this should stand as a great example to all public defenders that we're very thankful for the work that they do, which is severely underpaid, and yet they are able to save lives every day, like yours. So I'm wondering to what extent you can share with us the gymnastics that she had to undergo with clinicians, with other experts, in order to make sure that you were considered for treatment court, and that the court didn't just simply see you as your rap sheet.
Well, to begin, when I first met Gabriela Mejia in my arraignment, she came to me and we spoke, and she instantly knew that, like, I was going through something. I'm grieving right now, I'm hurt right now, and the drugs, the alcohol was just like making it worse for me, because I was trying to like forget, like the best way possible, and it didn't work. It just threw me over the edge. And when I told her that, she was like, "Yeah, I'm gonna get you to ATI. We're gonna move this over. Give me some time, but I'm gonna do my best," is what she said, right? And of course, at the time, I didn't have the greatest support system because I didn't have anyone to bail me out, So it was unfortunate for me to like go through the system, be in it, but she was with me all the way through. She would do the Zoom thing, and the COs would come and take me to like a private room. She would like check up on me every 2 weeks. Every 2 weeks. And I'm like, I never had a lawyer like this before, ever. She's like, yeah, I'm gonna need you to sign your HIPAA form, so I could get these documents and, get your medication and the psych ward and this and that. And I'm like, this is you, mommy. Like, this, if you was a lawyer, this would be you, right? But she just did her thing, and I'm forever grateful for Miss Gabriela Mejia. Like, she went when you have people that go above and beyond, these are people that I'll never forget in my life. And
I bet.
Gabriela Mejia is one of those people.
Yeah. Thank you for sharing that. I think very often we've seen how district attorneys or ADAs can be gatekeepers to treatment court. And I'm wondering, Ashley, what do you feel was the main obstacle for your nephew to get the mental health services that he clearly needs? And do you think that the judge might have a much more impartial understanding of the situation?
Yeah, thank you for that question. I think, as you said, as Senator Ramos, it was the ADA who was in the way.
Yeah, what was that ADA's name? I didn't catch it.
Amanda Fix.
Thank you.
Of course. I feel like she played the biggest role. Even when, she got that 23-page task report, it was almost as though, like, no, we did this, but it's not happening. We are going to prosecute your nephew. When I think, like, the reality is if my nephew was, like, maybe arrested, maybe just a little further south in Brooklyn, where there is a functioning mental health court, the circumstances of this would have probably been very different and very similar to my
Thank you.
fellow advocate.
And I want to remind everybody that this legislature did pass a law to halt solitary confinement, and that our prison complex here in New York continues to be out of compliance with the law of New York State.
Yeah.
Thank you. In 30 seconds, Nicole, I want to ask you, in your experience, do you think there would be more participants in treatment courts if you didn't have to plead guilty up front? And this is, of course, in both your personal lived experience, but also now as a peer specialist, observing, how people are experiencing the court system.
I'll give you a minute to answer.
Oh, thank you. That's generous.
Thank you. I definitely think it would help because me personally, part of my treatment plan was that I had to plead guilty, which, thank God now, going through the program, which I'm still in program. I'm still living in a reintegration house. I just recently made my year and 5-month clean mark.
Congratulations.
And I actually just also recently got offered the job for where I do work. I was interning at first, and my court case, everything has been expunged. But in the beginning, if it was a real hard decision to make to plead guilty to something that could have been proven wrong, especially with the case that I did have to prove guilty. I actually didn't do what I was being convicted of.
Did you just feel you didn't have the resources to prove your innocence?
Yeah, at the time, yes.
So this was just
And
easier to plead,
it was, yeah,
to plea and move on.
And it's like he was saying, in jail, it's horrible. And there is no help. Like, I got jumped in jail, and for the next 2 days, I didn't eat because of how depressed I was, and they didn't even come check on me. Nobody wanted to see if I was okay. They didn't even check on me after I got jumped. And it was difficult because my mental health was on the line at that moment. And it would seem that there was no resources to even help me with that. And if it wasn't for the treatment court, I would have still have been there, honestly. And I wouldn't have ever really gotten the help that I needed, because even in jail, there's drugs. Mm-hmm. And I would have never gotten clean, and I most likely would have never been where I am today.
Well, we're glad you are, and we're very proud of you and Selwyn. Thank you so much.
Thank you.
Thank you.
I just have a short question. Go on. More of just a little thing. So I hear your testimony, Selwyn. Selvin. That's it. Selvin. Right? Selwyn. My bad. I'm sorry. The actor.
Wins.
It's fine.
He wins.
You win with Selwyn.
But I hear your testimony, and I also connected to the past panel with Chief Justice Wilson and the letter that the judge received. And one of the things that we do not, we say of faith is something that's spiritual, but in nursing, that is a tool. that is a result of us putting in a caring framework that utilizes both medication, treatment, and just the power of human touch to build resilience. And to have the three panelists here who, through different experiences, are able to stand strong, be able to be productive members, particularly Nicole and Selvin, this is something we can put down as this is a success. This is a successful treatment that we are continuing to be in compliance with. To hear that just a couple of blocks away, that your brother could have been sharing in that success story. The facts are, in 2023, 4,300 people were arrested, and we know at Rikers, half of the people there have mental health disease, right? So 43,000 people were arrested, and 194 admitted into mental health treatment. Over in Queens County, where the money at, 3,500 people were arrested and only 27 new admittances. These are people that could have been saying, I have resilience now today. I can look forward to the future in spite of the past. It brings, I'm trying not to cry, but it warms my heart, but it also gives me so much purpose hearing the different testimonies today. And so can you tell me a little bit more about what that impact has been on your family to not be one of those 43?
It's so hard. I think a lot of folks, I can't even imagine the experience of being behind the walls, but the toll that it takes on the family to support a loved one who's incarcerated is emotionally, mentally, financially taxing. And as Nicole said, there are drugs in jails and prisons. And, my nephew, when you're in pain and you're dealing with cycles of trauma and there's no resources, that often ends to what we see like self-medicating. And I know my nephew has done that in the process of being on Rikers and in upstate prison facilities. I think for me and my family now is just preparing for, I think we're so excited for him to come home, but I think we're also very anxious. The amount of wraparound services that he's going to need, the amount of support. I think we didn't feel very equipped before he was arrested, to deal with his mental health and understanding how that shows up now, and the way that it's going to be exacerbated on his return home. It's going to be all hands on deck for sure. Yeah.
Thank you so much.
Thank you.
Thank you, Assemblymember. Senator, any questions?
Yeah, just a few. And to Nicole and Selwyn, thank you. Thank you for being here. Thank you for where you have arrived after being at another place. And I wish you continued success always. Ashley, about your nephew, just to put it in context, can you share what he was charged with, which got him that sentence of 6 years?
I can, but I will preface, though, I often find that when people ask that, they want to pacify or validify the things that he's went through because of his charge.
Well, I'm not going to do that, but also, too, if you don't want to say, that's okay, too.
No, I will. My nephew was caught up with a gun charge. He does have no one was hurt. There were not any victims. But I also think that ended up being as a result of a multitude of different resources that didn't or don't exist in the communities that I come from, that are often low income, Black and Latina, where our youth find mainly their only support system and sense of community is sometimes not in the best locations, because better locations don't exist.
And I understand that, and I agree with exactly what individuals can find themselves in different parts of our communities. So just so I'm clear, and maybe my colleague can help me with this too, you had said that because he was in Queens, if he had been in Brooklyn, it could have been a different outcome as it relates to drug treatment. Now, currently, again, I would imagine this, that there are drug treatment courts in the borough of Queens?
I believe so, yes.
Okay. And so the diagnosis that he got, the clinical diagnosis, outside of the fact that he apparently, based on the set of circumstances within the DA's office, as you're explaining it, they did not want to go there, right? In other words, so he was tried in a regular criminal court.
Yes.
Now, do you know, did that clinical diagnosis go with him when he was put into the custody of the Department of Corrections?
It did, yes.
It did, okay. And I think what you're saying is that because, of course, he didn't get into the drug treatment side, he's going into docs, the clinical diagnosis goes with him, but it is not, of course, anywhere near the same thing. There is no diversion, and you're in the state system, which, of course, has, as we've heard today, and we know, just like whether it's Rikers or local county jails have huge amounts of individuals in crisis and with mental health issues. And in the state system, it's even larger because there's more people. So I'll just end with this. So when is he due to come home?
Thank God the end of this month he
Okay,
should
great.
be coming home, yes.
Yeah, and so he will be released into the custody of parole?
Yes.
And have you at this point or your family members been in discussion with parole on what that's going to look like when he comes out?
So he should be receiving like an appointment with some reentry services upon his time coming home, and we've also been in correspondence with his old task coordinator to help him finding like programming as well as reentry. But of course, like those programs need to exist for more folks who are coming home because he's kind of privileged in that aspect that he had that before coming back home.
Would he be eligible or qualified for the MAP program? Does he going to need?
I'm actually not sure.
Okay.
Yeah, I'm not sure.
And not
So-
getting into the health related things, because I know that we've done work at the state level on things for reentry, and of course there needs to be more of it, more intensive analysis, therapy, and then the continuum of care. Right. I mean, you're on a parole for a certain period of time, and I think with your nephew, who certainly has challenges, that's intensive, and that is what, as we say, treatment is forever, right, and recovery is forever. Certainly like to know more about that when he gets out, and and I mean, again, I don't represent Queens County, but we have people who do, and they're here to make sure that parole is doing what they're supposed to be doing for this individual who deserves that chance and needs those supports. So I wish you and your family and your nephew the best.
Thank you so much.
And hope that he gets the things that he needs to make sure that he can have the success stories that we just heard this morning. So thanks, appreciate
Definitely, let's fund more folks like Nicole because I think they're very needed. That peer specialist,
Yes.
that person, yeah.
it. Yep, absolutely.
Thank you so much, panel. And just because you mentioned peer specialist, personally very excited that my bill with Assemblymember Chantel Jackson got delivered to the governor's desk to allow peer support advocates in our jails and prisons. So we hope that she signs that. Yes. Give her office a call. Make sure she does. But thank you so much for your testimony and for being here today and the work that you're doing. We'll go to the next panel now.
Great to hear.
Yeah, I'm excited. Thank you.
Oh, thanks.
Oh, cool. Thank you so much. Will you please introduce yourselves and your title and I guess where you're from? And then everyone will get their 5 minutes.
Hello?
I think he'll take care of it. Mic on? Mic is on, right?
Okay.
Yeah, there you go.
My name is Stan Herman. I'm the current president of the Chief Defenders Association of New York, and as well, I am the executive director of New York County Defender Services here in Manhattan.
Good morning. My name is Ilana Kotmar. I'm the policy coordinator as well as the county court staff attorney at Nassau County Legal Aid. And thank you for inviting me to testify.
Good morning. I'm Youngmi Lee. I'm the Director of Law and Appeals at Brooklyn Defender Services and also a past president of the New York State Association of Criminal Defense Lawyers. Mouthful. Thank you for having us.
Thank you. We'll start with Stan.
Thank you. And thank you, Senator Fernandez and Senator Ramos, for holding this important hearing on the urgent need to pass the Treatment Court Expansion Act. Thank you, Senator Rollason, for also coming down. I was on the 6:37 train, so I had you beat. Jersey. I was coming from Jersey.
Whoa, okay. All right.
And thank you to the Assembly member for sponsoring and being a champion of this bill for so many years. When drug law reform went into effect over 15 years ago, it was revolutionary. The legislation created the Judicial Drug Diversion Courts in every county through CPL Article 216. In Manhattan, where my office practices, prosecutor-controlled drug courts already existed, but they were tightly managed by the Manhattan District Attorney's Office with nearly insurmountable barriers to entry, exceedingly narrow eligibility criteria, overwrought admissions processes, and excessively punitive practices. Drug law reform ushered New York into a new era where judges controlled the admissions process, aided by professional clinicians, and removed the role of prosecutors as gatekeepers and pseudo-clinicians. This sort of sweeping landmark reform was not easy and took unyielding political resolve to accomplish. At the time, prosecutors and law enforcement across the state strongly opposed the legislation. They prophesied that the floodgates would open which would result in increased crime. And those jurisdictions with some sort of drug program alternative were adamant that they must have, quote, absolute control over the admissions process, or this would never work. Of course, none of these claims came to bear. Sadly, today we hear the same talking points from too many prosecutors, and it is quite disappointing that no one from the District Attorneys Association of the state of New York, or any prosecutor for that matter, has showed up to testify and answer your questions. Instead, they will likely rely on their traditional allies to oppose any reform of our legal system and engage in a campaign of fear-mongering through their friends at the New York Post. At their inception, drug diversion courts across the state did not become inundated with frivolous applications, but did experience modest, albeit significant increases in their diversion populations. Crime, already on a downward trend across the state, continued to drop. The new drug courts were not perfect and left much room for improvement, which TCEA promises to address. Most notably, CPL Article 216 ignores individuals suffering from mental health disorders, and many courts have interpreted the statute to also exclude those who suffer dual diagnoses, as we just heard. This constitutes a substantial swath of people in need of treatment. In response to this glaring oversight, a number of New York State counties took it upon themselves to fashion their own mental health diversion programs, typically operating in parallel to the Article 216 drug courts in the same county. Today, there are 40 such programs in operation, but only in 29 out of the state's 62 counties. While this is a testament to the goodwill, resourcefulness, and collaboration of the stakeholders in some jurisdictions across the state, the resulting court landscape has grown increasingly fragmented, siloed, and duplicative, and has shown racially and regionally disparate treatment. To those judges and prosecutors who feel that, quote, they don't need this legislation because things are working well in their county, I would suggest to them that that is a short-sighted and self-centered view. We cannot have a system in a diversion court that depends on one particular judge who may be doing a phenomenal job today. Because what happens when that judge is gone? When that judge goes on to the appellate division or retires? Are we now going to be subject to a new judge with a different perspective, perhaps a different level of engagement around drug diversion? And what happens if a elected DA who supports diversion suddenly loses an election or chooses not to run, and the next DA is opposed to it. What this legislation is about is making sure that regardless of your race, your socioeconomic status, or what county you are arrested in New York State, if you are in the crisis of a mental health episode and you find yourself in the criminal legal system, there is a drug diversion courtroom for you. Now, the drafters of this legislation have spoken to a lot of stakeholders over the last several years: defenders, prosecutors, program holders, OCA, and they have made numerous changes to this bill as they heard these different perspectives, right? They've abandoned a pure plea model, Senator Rosen, in favor of a bifurcated system divided by charge. They created a new class of presumptively ineligible offenses without prosecutorial consent. So there are charges where the DAs will have absolute veto power. They've raised the severity of illness required for admission, and they've required the defense to make a prima facie showing that the applicant has a qualifying diagnosis. This bill has emerged based on the feedback of all the stakeholders. But in conclusion, speak to defenders, and there are things that they want changed with the current legislation. Speak to some prosecutors who are open to the legislation. Guess what? They want changes too. Speak to judges around the state, and they also want changes. What does this tell me, senators? Is that the current legislation strikes the right balance. And it is time to move forward beyond the desired perfection that each stakeholder seeks and pass this important piece of public safety legislation.
Thank you.
Thank you. Good morning. First, I want to thank Senator Ramos and Senator Fernandez for sponsoring this very important revolutionary bill. And also Senator Rollison, congratulations on being a grandfather. It's the best club to be in as a grandmother of two.
He's a future co-sponsor.
Ah, okay, there you go.
I wonder when that was going to be said.
I have blood slip for you.
So for 33 years, I've represented clients charged with felony offenses in Nassau County, and I've had extensive experience in our drug court as well as our mental health courts. Since 2009, when Article 216 created our judicial diversion courts, I've seen firsthand how effective these courts are in treating clients with substance abuse. The clients work with a team. The treatment team consists of the prosecutor as well as the defense attorney and the judge. And it's a dedicated team to make sure that our clients are able to identify the triggers that cause them to relapse. Clients, this is not an easy program. Treatment court is not an easy way to deal with a criminal charge. The program is demanding, and the success requires genuine effort by our clients to succeed. But by addressing the underlying reasons why a person offends, which is so often rooted in addiction, clients can chart a new course for themselves to maintain sobriety and lead a stable and law-abiding life. And over the years, I've received so many calls and text messages and emails from former clients of mine who have told me that if it weren't for the treatment courts, they would either be upstate in a prison or they would be dead. And the most heart-wrenching thing for a defense attorney is to see clients who I cannot get into these courts, clients who need treatment, but I cannot get into these courts because the Article 216 is too restrictive in their eligibility requirements. So first of all, eligibility currently for the Article 216 is limited to only to certain drug and nonviolent theft offenses and misdemeanors. What is excluded are misdemeanors, DWI offenses, and anyone who's charged with a violent offense or anyone who has a prior violent felony conviction within the past 10 years. These restrictive eligibility standards leave way too many people in need of treatment behind. Another flaw, as we've discussed many times, is the upfront plea. From a defense attorney's perspective, I can tell you that these contracts expose, our clients have to sign contracts where it lays out in the contract what they will receive, what type of punishment, sentence that they will receive if they cannot be successful. These contracts expose our clients to lengthy prison terms. Often, my clients are forced to sign contracts where they're looking at 4 years, 5 years, 6 years upstate if they are unable to graduate. I have clients who cannot even string together 2 days of sobriety, and yet now we're asking them to sign a contract where they are now being told that if they're not able to maintain sobriety, that they're looking at 6 years upstate. that is such a disincentive for our clients to ever want to even like sign up for something like that. They are deterred right at the get-go. And for a defense attorney, where I know where I can get a better plea bargain for my client, where they're looking at probation maybe, or even way less jail time, why would a defense attorney allow their client to take such a risk or a gamble? So these upfront pleas actually deter and disincentivize many clients for actually the clients who need to be in these treatment courts, but they're too afraid to even enter into these treatment courts from the beginning. Equally troubling is that the Article 216 statute only allows people who have substance abuse issues. It excludes anyone who has mental health issues. And this is obviously a very glaring omission. And New York State has dropped the ball. There are mental health courts, as we've discussed, but these mental health courts are run by the district attorney's offices. They are ad hoc, and every single mental health court has their own guidelines, their own criteria, their own admission eligibility. And because of that, these mental health courts are underfunded and they're underutilized. For example, in Nassau County, last year, out of the 14,000 people who were arrested, there are only 10 people who were admitted into our mental health court. Why is that? It's underfunded. It only can fund, the mental health court can only fund 36 participants. That excludes so many people who do have mental health issues. They're not able to get into these mental health courts. Additionally, unlike our Article 216 courts, where judges are the ones who decide who are eligible and who are able to be admitted, these ad hoc mental health courts are run by the district attorney's offices. They are the gatekeepers. They are the ones who decide who's eligible and who is going to be admitted. They are the ones who determine the criteria as to who's going to graduate and who's going to be terminated. The Treatment Court Expansion Act levels the playing field, so it gives the judge the ability to determine who is eligible, who will graduate, and who will be admitted. I urge the legislature and the governor to bring the opportunity for change and treatment and rehabilitation to all those who need it. Thank you.
Thank you.
Thank you for giving me the opportunity to testify today. I have been at Brooklyn Defender Services since 1998. I've been a public defender for 27 years. Many people, and you all know, that I practice in a jurisdiction that a lot of people hold out as the national model for mental health courts. So I do want to talk about its successes, but I also want to talk about my 27 years as a public defender, where I have seen change. And I think what's really important is for people, everyone, legislators, DAs, the unified court system, to embrace the fact that we have to change our mindset in terms of how people with mental illness or disabilities are treated. And I say this because everyone is saying we need a pre-plea model. Everyone should plead guilty up front. Why? As a public defender for 27 years, I know that people who are in the treatment court system who have been forced to plead guilty, I've seen their success stories, but no one talks about the people who are turned away from mental health court treatment. Some people don't want to plead guilty because they're not guilty, but they want treatment. They don't want the risk of going to trial. Some people, as Ilana said, just cannot face that 10-year alternative for trying to do treatment. So, I'm sorry, I'm so thirsty. These are some of the changes that I want to talk about. When I was practicing under Article 216, the judicial diversion laws, we had a judge who was willing to take the risk and to allow judicial diversion. But the default was, if you had a prior felony conviction, you had to go residential. I represented a man who said, I can't do residential. I'll lose my supportive housing. I have a dog at home. And if I do residential for even 8 months, I will lose all of that. I will come out and not have a place to live. The judge had mercy, even though the DA insisted this man had to do a residential program. The judge allowed him to do it. And this is the amazing thing. This man because he was being a decision maker in his own treatment plan, successfully completed. I'm not saying it was a linear successful, but he was very involved in his own treatment plan. This is the type of mindset, the change in mindset that has to occur within all of the stakeholders, including myself, because I was telling him, you are not going to get this treatment offer unless you do residential. And he said, I just want to talk to the judge. He did it. It happened. This is what has to happen. Methadone maintenance. People were rejected from treatment courts if they were on too high a dose of methadone. Out of the blue, right? So I represented so many people who had too much of a high dose of methadone, and so they couldn't get into treatment. Out of the blue, someone decided that they should listen to the clinical experts. It's okay to be on methadone maintenance and to still have a successful graduation. So I just in terms of changes, what happens in the Brooklyn Mental Health Court, which should be happening throughout the state and maybe nationwide. I want to talk about a couple of clients, but I have to have a sip of water. I once represented a young woman who was charged, indicted for attempted murder and assault 1. She stabbed another woman outside her apartment. Sounds really serious and horrible. She was a young woman. What happened with her, though, was that the woman who she stabbed was someone, and this took a while to drag out of her, was trafficking her. So eventually what came out was my client, who suffered from terrible PTSD, but that's not readily apparent when you meet and talk to people. And it's not something that people want to talk about. The charges were very serious. I found out that this was happening, and we were able, and the judge was willing to take the risk. The plea offer on her case was 8 years, not even the minimum for someone who had first been arrested. She was able to get treatment, a violent felony offense. Take another story of DT, a young man. He was 6'5", incredibly muscular. His 65-year-old neighbor was coming home from a dinner with his family. My client allegedly ran out of the apartment building with a fire extinguisher and hit the 65-year-old man in the head. He was seriously injured and ended up being hospitalized. After a while, I learned he was an Army combat veteran. He had actually seen combat in the Middle East. He had emerging paranoid delusions, and that was what he was experiencing at the time. The PTSD did not help. Serious violent felony, he was offered treatment. Again, his treatment course throughout MD1 was not linear, but he was allowed to do treatment. These are success stories within MD1, but I also think about all the other people who've been charged with violent felonies who are not allowed to get treatment. And we have one of the most successful, we have the highest rate of participants in Brooklyn, but I think about all the other people who were denied treatment, the other people who would not or could not plead guilty for whatever other reasons, who should have received treatment but didn't get it.
Thank you. That was going to be actually going into my first set of questions of people that have been denied and the effects of it and how it makes your job harder. You can continue, but I'm curious, for those that were excluded, how could they have benefited and how has the exclusion hurt them?
Well, unfortunately, what happens when they're excluded is they end up going to prison. And obviously, the mental health system within the prison system is just not adequate. And you will see, I've represented people where I can even see on the rap sheet where people within the prison system are sent to an OMH facility. People do not come out for the better when they are suffering from a mental illness, a mental disability, when they have served a prison term. I can tell you I've represented people who come out of prison who have had the PTSD diagnosis, and it's from being in prison. It's not because they were experiencing PTSD before. So it's a tragedy. And what's even worse is, I think, for the families, the panel that spoke before our panel, it's also extremely difficult for the families. It tears them apart. And it's really something, I think, that hits the Black and brown New Yorkers the worst. I think there's also a serious misunderstanding in terms of mental illness when it comes to treating people of color, not just in New York State, but throughout the country. And so I think MD1 in Brooklyn is great. We have a judge who is sympathetic, who is empathetic. He understands the treatment process, but there are way too many people who are turned away from his court.
Thank you. Currently, individuals with mental health disorders and dual diagnoses are often excluded from diversion programs. From your experience, how critical is it to integrate co-occurring disorders and treatment into judicial diversion? And I'll let anybody answer that.
I can answer it. I've had many experiences where I've had clients who have a dual diagnosis, and first I'll refer them to our judicial to the Article 216 court because we have some incredible case managers there that are really great at treating our clients, but they don't have the same expertise in mental health diagnoses, so they're not admitted. They're found ineligible for our diversion court. So then I'll refer them to our mental health court, but they're not eligible for our mental health court because they have a substance abuse issue. So we have a number of clients who just fall through the cracks. They're not eligible for either of those courts. And it's terrible because we have these clients who we know if they could just get treatment, if they can just avail themselves of the case managers, there are some great case managers in both mental health court and judicial diversion courts. But unless they're able to work together, and that's the beauty of TCAA, because what it does, it brings everyone under one umbrella. So you can have the case managers, you have substance abuse case managers sitting right next to an office, right next to mental health case managers, and they can look at a client holistically, and they can try to then treat the client for all of their issues. And we're going to be able to get so many more people into treatment. It will just, it will, as we've all said, lower recidivism, create more family stabilities, and also create safer communities.
Thank you. Do you foresee any challenges with judicial discretion that lawmakers should consider?
Sure. I think Chief Judge Wilson earlier this morning spoke about the need for training. I'm not a mental health specialist. I think the clinical best practices are really important. I think a lot of judges and a lot of DAs don't understand that the path towards successful treatment is not linear. There will be setbacks. Things happen in life. Sometimes people stop taking their medication if they need it, and they need to get back on track. And I've seen way too often the use of jail sanctions when people fall off the track or they fall off the wagon. And I have found that that doesn't really help towards successful treatment, but it's something that judges will utilize because they're also afraid, I think. I would love to see one day, and I think the Treatment Court Expansion Act is what's so important about it also is that there's an emphasis on clinical judgment and expertise.
And if I could add, I think that's where the role of data is incredibly important. And I know it got raised with the chief administrative judges. If you have a county, like in Queens right now, that has 27 individuals, and then you have a county in Brooklyn that on an annual basis is letting in 200, I think if we have the data, it's a conversation that we have to have with the Queens Mental Health Court judge of, why is there such a grave disparity. So I think collecting data is going to be crucial to address all kinds of disparities, and also, on the issue of training, who needs more training, who needs to maybe take a different approach.
Thank you. Senators?
Yeah, thank you, Senator. I want to continue the conversation on prosecutorial gatekeeping. Can, among the three of you, talk about what the process is like to work out a plea before treatment court with the DA or ADA? What does the DA require from your clients in order to consider them for admission? It's unfortunate that none of the district attorney offices are here today, but my understanding is that much like many police officers have arrest quotas that they don't talk about, district attorney offices also have plea quotas sometimes. And so I want to understand, or especially for people watching at home, I want them to understand kind of what those conversations are like, what the process is like.
Right. So, I mean, first of all, I'll say I've never heard of a plea quota, to be honest.
I have.
I don't think that I've ever heard that term with regard to New York County. But in New York County, it is an onerous process. You have to get in the case of Mr. Selwyn, who spent 6 months before he was released, that's actually quite fast for New York County. We actually see that, from the time of arrest until the time if you are accepted and cleared and placed in a treatment program, it's a lot closer to 9 months. A large part of that is the process that Danny takes internally to make their assessment. In my opinion, I think it takes too long. I think if you juxtapose it to what's happening in Brooklyn, the public safety assessment is a lot faster in Brooklyn County. And what that allows is that it allows the clinicians and the professionals in the treatment court to spend that time doing their evaluation and coming up
Why
with...
is it faster in Brooklyn?
Well, I mean, I will let young me talk about what the process is in Brooklyn.
I think our ADA is willing to take a discharge summary with a diagnosis, and they just they have probably streamlined the system a little bit better. So it doesn't require as much of that. Is it the control freakiness of the Manhattan DA's office? I mean, I get the sense that we also, as I think most public defender offices do, we have a specialized mental health unit. And so we have social workers within that unit and the attorneys also. And when they talk to the ADA and they say this person should really be evaluated, we've also done. And I think there's a certain amount of trust that the DA has in our mental health unit.
I think it's also just the sheer evolution of the court. I mean, former DA Ken Thompson was a big champion for treatment court. And, we want to see that type of approach across counties.
One big difference in Manhattan is that we have to do proffers. So aside from getting together all the materials and presenting them to the DA's office and their pathways team, we then have to meet with our client, bring our client, meet with the DA where there's a proffer session, there's questions asked. Sometimes that leads to more follow-up of more records. And so it is simply a much more rigorous, lengthy process before we even get to the ATI program, where they then begin to do their assessment.
So that's 9-10 months without these individuals receiving the treatment that they need.
That's exactly right.
Awaiting trial, maybe they're out, but maybe they're in Rikers where they're in harm's way.
That's exactly right.
What kind of punishment, very quickly, what kind of punishment would your clients have faced had you not been able to intervene? I want to make a point.
I mean,
what types of sentences have been avoided?
It's mostly prison sentences. The majority of the people we represent in MD1 are indicted for violent felonies. Some are deemed predicates. I don't love that term, but they have prior felony convictions. And so prison is mandatory should they go to trial and lose, or even if they were to take a guilty plea on a felony. So some of these cases, our clients are facing, even if it's a first be violent, 5 to 25 years. Those are very lengthy prison sentences for people who, like I said with my previous client, DT, I mean, he was charged with a B violent felony. He didn't have a record, but he was facing a lengthy prison sentence.
And I think what's disturbing, Senator Ramos, in some counties, this is still the practice, where the plea offer, if you just plead guilty and decide to go to prison, is lower than the hammer if you enter a program and you're not successful. So they may offer 2 years, go upstate, do your time. But if you want a program and you're not successful, then it's going to be 4 years. And so when you talk about an incentive not to get help, that's going to disincentivize a lot of people who are fearful, what if I don't make it through this program? I'm actually going to spend more time in prison than if I just plead guilty.
Well, so to offer some loosey-goosey math, if someone would have done 25 years, now we know that, spending time in Rikers, it's to the tune of $500,000 a year, $500,000 a year per person. That means that you saved New York State on that one client over $12 million, $12.5 million were saved to the taxpayer by that person avoiding the 25-year prison sentence on average. And instead, that person was able to get treatment, probably at a lower cost to the taxpayer and to themselves, and was better off for themselves, their family, and was still held accountable for...
And he was able to finish college and get a job. And he saved his mother years and decades of heartache, I'm sure.
I think similar to the drug reforms of 2009, not only did it make New Yorkers throughout the state safer, it also saved New York taxpayers a lot of money.
Thank you.
Thank you. Senator Rollinson?
Thank you for being here. When you're talking about the boroughs, the counties of New York City, and each one has some version of treatment court or courts, and as you had said, Brooklyn seems to be the model. Next door, Queens could be different. So how does that impact, a model of let's say New York City? The New York City model is different because of the different counties and how they do things, and different elected officials, et cetera. But the cross-county collaboration and a standard of continuity, so that someone can be essentially getting the same benefit for the same alleged offense in multiple counties, because obviously many of our individuals who are in crisis, who are committing crimes, are committing them in different parts of, say, this city. And I know each one it's their own way of doing things, but what do you, maybe I haven't phrased this the right way, but, continuity and dependability of treatment wherever you are, the standard that would be set potentially by this law makes sense to me. Am I right in that observation?
Yeah, and I want to highlight something also. We have a lot of clients who come from Queens or Suffolk, and because our mental health court only funds for Nassau County residents, we exclude right there a lot of people who have mental health issues but are not eligible for a mental health court. So when you talk about how do we make sure that there's continuity, well, that TCEA gives that continuity by allowing everyone, no matter what county you're from, access to treatment. So that's.
I think you want eligibility to be the same across the state. But we all have to recognize this is a very large state, the North Country, Western New York, and that there are going to be particular issues to that state where perhaps the help that they're getting, the way it looks, where they go, you have to allow for that kind of regional differences and take advantage of what's there in each of those different parts of the state.
And for your respective jurisdictions, let's say that you were going to expand, and the things that you wanted to see within the system are there for you, those supports. We know right now it doesn't exist in many places. Like, say, Brooklyn. If you were to have more people go through the drug court, can the service providers that currently exist in Brooklyn, would they be able to adequately, work with, administer, and try to work for those outcomes? Or would there need to be more providers, more money, et cetera? We talked about this a little bit earlier with judges as well.
It's a complex question because I do feel that some people are over-programmed. And so if we're spreading out the resources so that clinical best practices are used, then that would be the most efficient and effective way of using the resources that are available out there. I do believe that some people, like with DTaP plea agreements in Brooklyn and Manhattan, that long-term residential treatment requirement is unnecessary. And that is not a good use of a scarce resource. So I think if we actually listened to the clinical experts who said this is what the treatment plan should look like, versus the DA saying this person has to go residential for 12 months, then we would just have a much better use, a much more efficient use of the system and what's out there.
I do think, though, Senator, that when it comes to serious mental illness, I think we all need a lot more resources. Right now, if you are found unfit in New York County or in New York City on the 730 exam, folks are waiting 5-6 months to get placed with OMH. And so, you know, and we need housing. I mean, if you speak to our social workers, the number one thing they will say is we need supportive housing. Absolutely.
And I know the governor in last year's budget had talked about, I think it was last year's budget, had talked about increasing funding for beds. Really related to people on the street is what it really came. That was where she was going because of the issues in many communities, especially New York City, subway challenges, et cetera, with not necessarily committing crimes, but living on the streets. Those beds needed to be created. I know some are being actually constructed in Orange County, just outside of my district, in the Hudson Psychiatric Center. But this is different a little bit. These are people who were charged with crimes, and if you don't have the beds, let's say you do need residential, that becomes a challenge as well, you know, with an expansion, that you can't say we're going to try to help you, but yet it's going to take, in the case of New York County, 5, 6, 7 months to find that location. And then while we're looking, are they in a local correctional facility, saying we're talking about Rikers in the city, that certainly, you know, is not adequately being able to do the things that we'd like them to do. So
I certainly think.
Wait, can you just put 3 minutes, because I'm taking this as your second round. So 3 minutes on the clock.
I was just going to say, I certainly think we need to do both. You know, we're not looking for more clients. You know, if we could get those services to folks, you know, desperate people do desperate things, right? And so if we focus on the folks who need those services, who aren't criminally justice involved, then they're a lot less likely to end up being our clients.
Good. Thank you all. Appreciate it.
Okay, that's it. That was good. All right, any second round? No? I don't either, but let's take now the end of this panel for a 15-minute break for water and restroom and everything, and we'll come back shortly for the fourth.
All right, thank you.
Thank you.
Thanks, Senator.
No problem. Okay, we're going to get started. Everyone, please take their seats. Alrighty. Thank you so much. We'll start at the end here. Please introduce yourself.
Nadia Chait Cases.
Thank you.
Nathan McLaughlin, NAMI, New York State.
Justina Rosinski. Laura Robinson, clinical mental health counselor.
Thank you. We'll start with you for your 5 minutes.
Thank you, Senator. I'm Nadia Chait. I'm the Senior Director of Policy and Advocacy at Cases. We have been providing alternatives to incarceration for people involved in the legal system since 1967. We were one of the first ATI programs in New York City, and so we have a wealth of experience of both why we strongly support the Treatment Court Expansion Act, what programs look like on the ground, and why we need to really, at this point in time, systematize what our treatment courts look like. We served over 13,000 people last year across a wide range of programs, but at the heart of all of our programs is a deep belief that what people need is support and care and not punishment. Many of our alternatives to incarceration programs focus on serving individuals with mental health challenges. And one of our most intensive programs is the Nathaniel Assertive Community Treatment Alternative to Incarceration program, which when it started, and it was the first ATI ACT team. ACT is a longstanding mental health model that provides intensive community-based treatment to people with serious mental illness who have histories of hospitalization, emergency department use, and haven't been able to succeed in kind of the more traditional forms of treatment. And we were able to innovate and actually use that as an ATI by adding additional resources to do intake at court and on the court compliance side to have court specialists. So clients come into that program exclusively on felonies who are facing at least a year in prison. It's a pretty intensive program, so it's not the kind of thing that we would want to mandate people into who are, just on low-level charges. And the program has an incredible success rate. We see a 70% decrease in homelessness among our clients at graduation, and of clients who enter on a violent felony conviction 2 years after they've graduated from the program. So they've spent at least a year in the program, they've done their mandate. 2 years after that, 0 have new violent felony convictions. So we are changing the cycle of people's lives. And I want to talk a little bit about what that looks like for a couple of our clients. So recently we had a client, Mr. A, who came to us. He had been incarcerated on Rikers for 3 years before he was able to access treatment and get into this program. He had schizophrenia, depression, and alcohol use disorder. And unfortunately, he had attempted suicide multiple times, including one attempt that left him with a serious and lifelong injury. When he came into our program, he was really without hope and really felt that based on his time in Rikers and his diagnoses that, that his life was just not going to be a life that he wanted to lead. But we were able to connect him to treatment and to medication. We were able to help him qualify for the benefits that he should be receiving. And perhaps actually most impactfully, we were able to get him mobility supports so that that injury that he had wasn't something that was keeping him from being able to be out in the community. And he could resume things in his life that he enjoys. He also received substance use treatment through us. He was able to complete court successfully. This is an individual who had had many hospitalizations. He has not been hospitalized since he's been in our program. And although he's done with his mandate, he stays engaged with us in voluntary services. He's transitioned to one of our ACT teams that's not an alternative to incarceration. Another one of our clients came to us with a very complex life. This is a client who has a pretty extensive history of arrests, has schizophrenia, but also has lead poisoning from his childhood. And so, I think often those are exactly the kind of clients who fall through the gaps because, you don't fit in the drug treatment court bucket. You don't fit in the mental health court bucket. You didn't get into OPWDD at a young enough age to qualify for services, right? But fortunately, this client came to us through one of the ATI court parts. And so we are able to serve this individual, with all of their challenges. We've been able to connect him to a range of services. He's now in substance use recovery. He's regularly attending both his mental health and his medical appointments, and he hasn't missed a single court date. So those are the kinds of results that we can get when we actually invest in treatment and give people access to treatment. And I think as we look at systemizing this across the state, I would say it's so critical to center the role of clinical professionals. And I would also say this is not a choice between whether or not we have mental health courts. 4 in 10 people in our state prisons have a mental health diagnosis. Every single criminal court in the state is a mental health court because they are dealing with individuals who have mental health challenges. This is a choice that we can make about whether we respond to that with diversion in resources or whether we continue to incarcerate those individuals. Thank you.
Dr. Carol Ann?
Yes, sorry. Yes, Dr.
From
Samaritan
Dr.
Club
Slattery.
Village.
Thank you for joining. We'll get to you after you.
So, my name's Nathan McLaughlin. Good morning, and thank you so much for having me. I'm the Executive Director for NAMI New York State, the National Alliance on Mental Illness. We're part of the nation's largest grassroots mental health organization, representing families and their loved ones living with mental illness. We provide free programs, education, advocacy, and support to these individuals and their families, while also working to make sure that all New Yorkers have equitable access to quality mental health care. So thank you again for the opportunity to testify in support of the Treatment Court Expansion Act today. I took the 5:45 train from Hudson, so it's an early start. I know. Hudson.
Hudson.
Yeah.
Amtrak.
Amtrak.
Yeah. Yeah.
It's a beautiful morning.
I think that train goes by where I live at 6:53. Just
There you go.
Matter
That's
of
fair.
fact, I know it's 6:53.
That's fair.
Yeah.
So as we know, New York treatment courts operate under a bit of a patchwork system and are in desperate need of streamlining. Jails and prisons have increasingly become our state's de facto psychiatric institutions. And the mental health care people receive while they're incarcerated is not really at a high quality standard. And people inevitably then return to our communities more destabilized or freshly traumatized. And this act really offers a solution to that problem. Evidence-based practices, which we've heard about today, will allow this to be successful. And I've seen firsthand the impact of these courts. So in the city of Hudson, where I live, we have a treatment court based there in the city of Hudson, not at the county level. And these graduation ceremonies are truly inspiring. This is where we see people achieving sobriety, making their way to treatment, finding a pathway to recovery, in many cases reconnecting with their families, finding pathways into the workforce, and then mentoring others through their recovery when they're on the other side of it. Graduates often remark there that people leave the program with stronger support systems than they had going into it. And these aren't isolated stories. These are across the board for those graduates. But when we talk about stronger support systems, from the NAMI perspective, this is where we really feel it's important to note that's how these treatment courts are successful, which is collaborative treatment teams. If you attend the Hudson City treatment court graduations, that treatment team is there and has representation from law enforcement to substance abuse treatment to mental health treatment. And those teams really work collaboratively to understand the situation and support that person all the way through. And for me, it's really great to be in that room and see such a diverse group of people supporting those graduates. It also really provides that equity and accessibility, right, that crosses any borders of geography, race, income, provides truly equitable access. Families that attend those graduations see their family members in a new light, right? They've probably been through a lot of trauma themselves. Now they can see this person really be successful. So we believe that not only will this make our communities safer and more resilient, it will ultimately save taxpayer money. Recidivism for individuals with mental health challenges is quite high, further decompensating at each experience as they relapse or have another issue that comes up with the criminal justice system. We believe that those treatment courts could cut recidivism in half and grow employment rates for that population. Right? So now they're becoming really productive members of society. So NAMI New York State strongly supports this act and the values it represents, which align with our values: treatment over incarceration, recovery over punishment, dignity over stigma. It recognizes that our criminal legal system is not necessarily the right place to treat serious mental illness or addiction. We urge the committee to advance this legislation and pair it with sustained investment in the behavioral health system so that these courts can succeed. Thank you so much.
Thank you.
Good afternoon. Thank you for the opportunity to testify today. My name is Justina Rosinski, and I'm a licensed clinical social worker. From December 2023 to September 2024, I worked in the mental health units on Rikers Island, specifically the mental observation and PACE units, places that are supposed to provide the highest level of mental health treatment. What I witnessed there was devastating. I'm sorry. Just last year, on October 8th, I testified about the practice of deadlocking people with serious mental illness, and not a single day has passed that I still don't think about those individuals that I left to suffer. And it pains me deeply to sit here 1 year later and know that so little has changed. So while I was working there, I saw people with serious mental illness being locked in their cells without medication, without any therapy or meaningful human contact. They were locked in their cells for weeks and even months. They deteriorated until they were smearing feces, banging on doors, and crying out for help. And these were not acts of defiance. They were the visible symptoms of untreated mental illness. And the most haunting recent example is of Mr. Ardit Bila, who was found dead in a PACE unit, smeared with feces in his cell. And the truth is this: nobody is receiving meaningful mental health treatment on Rikers. People are being warehoused in cages, left to deteriorate, and then sent back into our communities more traumatized, more destabilized, and in worse conditions when they entered. Rikers is not a place of healing, it is a place of harm. And this crisis is not an exception. In New York City jails today, 1 in 5 people, 21%, are flagged as having a serious mental illness, and about half have some mental health diagnosis. And nationally, we know that 44% of people in local jails report a history of mental illness, yet 63 of incarcerated individuals with mental health conditions never receive treatment while inside. This is why I strongly support the Treatment Court Expansion Act. Right now, New York operates under a patchwork of limited drug and mental health courts, and this bill modernizes and expands the system to provide a statewide evidence public health solution. The Treatment Court Expansion Act does 3 important things. It expands eligibility to include people with a wide range of mental health diagnoses who are currently excluded, and it ensures that licensed clinicians make treatment decisions. It embraces a pre-deal model for nonviolent cases so people can access treatment immediately without being forced to plead guilty first. And this legislation will not only make our communities safer and healthier, it will also save lives and money. Experts estimate that expanding treatment courts, we could cut recidivism in half, grow employment rates by 50%, and save New York State nearly $2 billion. And reduce jail and prison costs over 5 years. I spoke out as a whistleblower about the inhumane conditions I witnessed at Rikers because silence was complicity. Today, I speak out again because every person deserves the chance to heal, not to die in a cell smeared with feces. Passing the Treatment Court Expansion Act is not just a good policy, it is a moral obligation. Thank you.
Ms. Robinson?
Good afternoon. My name is Laura Robinson. I'm a licensed mental health clinician in the state of New York and a first-time testifier. So I just want to thank everyone for allowing me to be here today. I want to thank my panel of professionals because it's a lot. It's a lot to come forward and talk about your experience and what we see in the courts and how TCEA is going to really improve and expand in New York. And when this does pass, how much it will improve the lives of the folks that we dedicate our time to. I began my career working at the Center for Alternative Sentencing and Employment Services with actually a few individuals behind me who, without their service as public defenders, who I very much appreciate, would have never really found myself working within the justice-involved population. I recognize a lot of Friday mornings standing outside of Judge Merchan's chambers with Jeffrey Berman, who's right behind me, chatting in collaboration around client
correct?
care.
I'm sorry, I felt like your time went really quick. It beeped early.
It wasn't. I think it was.
It wasn't even on?
Yeah, it's okay.
Oh, okay, just continue.
No worries, no worries. So just recognizing that as we were outside during our rally this morning, remembering Friday mornings with Manhattan Mental Health Court and Judge Merchan, and partnering with Legal Aid and other public defenders through this process. So I began my career at cases meeting with clients struggling with serious mental health conditions and substance use disorders. For many, their charges were symptoms of untreated illness. When they were offered treatment instead of punishment, they actually stabilized, reconnected with their communities, and completely changed the course of their lives. In 2021, I relocated back to Western New York, where I was born and raised, and I saw a stark contrast in how treatment courts are implemented across the state. In some counties, these courts were collaborative and restorative. In others, punitive responses remained the default, and people fell back into cycles of recidivism simply because their underlying conditions went untreated. Incarceration rarely, as we have all heard today, solves these problems. The Treatment Court Expansion Act offers a smarter, more humane approach: treatment first, accountability second. When we talk about treatment, it's not just a straight line. Recovery happens with setbacks and successes depending on persistence, opportunities, with a team of peers, case managers, therapists, social workers, nurses, psychiatrists, and physicians. There are so many people in this room today that dedicate their time and their life to the folks that we serve, and I really want to recognize them. Just as importantly, treatment extends far beyond the clinic. It means stable housing, counseling, medication, job training, continuing ed, family reunification, trauma-informed care, and recovery. These are interventions that restore lives and break the cycle of justice involvement. Let me just share a quick example while working with the Nathaniel Act team. And again, I know it was kind of described, it's a 5-borough system, so we are backpack therapists out in the field. And I was fortunately one of the court liaisons. Working with a client who was initially charged with assault. The incident was a direct result of untreated schizophrenia, and those internal voices pushed them into that crisis. This individual spent 29 months on Rikers Island before receiving a proper diagnosis and medication. For years, they had been denied the help they desperately needed, and it shouldn't have to take an arrest to access treatment. Through the treatment court process, this client was finally released to the Nathaniel Act team. With their support, they were able to stabilize their mental health, secure housing, and even enrolled in school. Most powerfully, after graduating from the program, they were able to apologize directly to the person that they had harmed, demonstrating not only accountability, but the ability to live a safe, healthy, and law-abiding life. That transformation was not only the product of incarceration, but it was a result of the treatment and accountability working hand in hand. Now that I live in Western New York and I'm a program director for the Justice Involved, I have seen significant gaps within the system in the state. While some courts embrace collaboration with treatment providers and respect clinical recommendations, often, too many times, those potential candidates can be overlooked. Diagnoses can be used against them, and clients' efforts towards treatment goals are sometimes second-guessed. Licensed clinicians are also denied the voice in the courtroom, while non-clinical court staff sometimes or often make treatment recommendations. I have seen these individuals held in treatment courts for over a decade on a misdemeanor charge, deepening the justice system trauma rather than resolving it. I've also observed abstinence being a requirement as the only path to sobriety, as a practice that can certainly endanger clients who need a safe, medically supported, harm reduction approach to their recovery. We cannot have a faithful system if it is not practiced and in bad faith. The Treatment Court Expansion Act will address these gaps, expand eligibility to people with mental health and substance use disorders, and obviously continue to improve our own communities. Over the years, I've watched people once trapped in cycles of incarceration become employees, parents, neighbors, and mentors because they were offered this alternative instead of punishment. They earned diplomas, secured jobs, stabilized their health, and reunited with their families, outcomes that incarceration alone could never achieve. By passing TCEA, we are investing in restoration. We are choosing to see a whole person, and we are equipping New Yorkers with the tools they need to succeed. We are sending a powerful message that justice in New York is about healing. It's about second chances, not permanent labels. It's about a safer and healthier community built through compassion and accountability. This is not a concession. This is a commitment and a smart investment in public safety, equity, and human dignity. Thank you.
Thank you so much. Dr. Slattery?
Thank you for allowing me to come today and speak to you about this very important act. I strongly support it as well. Currently, I serve as Chief Clinical Officer for Samaritan Daytop Village. We are one of the largest organizations, behavioral health, in the state of New York. We serve Long Island, all the boroughs of New York City, Westchester, Rockland, all the way up to Ulster County. We have transitional housing, residential, outpatients, ACT teams. We serve approximately 45,000 lives a year. So I can honestly say I'm very passionate about this topic. I see every day the failures of our current approach, people with treatable conditions cycling through jails instead of receiving the care that is needed, treatment courts that exclude those who need help most, a fundamental contradiction we claim to offer treatment while using threats and incarceration to enforce compliance, approaches that contradict everything to know about recovery. I am a practitioner and I use research and science for decision-making and also for review. Coerced treatment with punitive sanctions does not work, as well as voluntary harm reduction-based approaches. Recovery requires participant buy-in, and that is the hugest point, is the buy-in. Yet our current drug courts often mandate abstinence-only programs, prohibit evidence-based medications like buprenorphine or methadone, and jail people for relapse, which we all know is part of the recovery process. This bill corrects those fundamental flaws. When reading the bill, I saw 3 key provisions that I felt needed to be emphasized. The first is eliminating the guilty plea requirement for most charges protects people from collateral consequences that undermine recovery. I've watched clients successfully complete treatment only to lose housing, employment, or immigration status because of their plea. The criminal record becomes a permanent barrier to stability. Pre-plea diversion preserves due process while providing treatment access. Second, the harm reduction framework is evidence-based. The bill allows medication for addiction treatment without court interference, recognizes that reducing use can be as valid as abstinence, and prohibits jailing people for clinical decisions. This aligns with the American Society of Addiction Medicine standards and decades of research. When we meet people where they are, outcomes improve. Third, expanding eligibility removes arbitrary barriers. Currently, most counties lack treatment courts entirely. Where they exist, people with serious mental illness, intellectual disabilities, or the wrong charges that deem them ineligible are excluded, even though these populations desperately need alternatives to incarceration. The bill's qualifying diagnosis framework is clinically sound. It includes serious mental disorders, neurodevelopmental conditions, and substance use disorders. It recognizes that trauma, psychosis, bipolar disorder, and cognitive impairments drive justice involvement and require treatment, not punishment. The bill also includes critical clinical safeguards. Treatment plans must follow evidence-based practice from OASIS and OMH. Licensed mental health professionals, not judges, determine clinical appropriateness. Participants can seek second options, privacy protections, limit what courts can access. These provisions respect the therapeutic relationship and clinical expertise. I want to address public safety directly. Research shows that diversion programs reduce recidivism more effectively than incarceration. Studies demonstrate that people charged with violent offenses do just as well in treatment as those charged with nonviolent offenses. Most importantly, people stabilized in treatment are less likely to reoffend. This bill enhances public safety by addressing root causes rather than cycling people through the jails. The graduated response system replaces summary incarceration with clinically appropriate interventions. Courts must prove violations by clear and convincing evidence. Participants can present defenses, and crucially, the bill recognizes relapse as part of recovery, not grounds for automatic termination. This is how effective treatment works in community settings. Why should court-involved treatment be different? From a provider perspective, current limitations prevent us from delivering optimal care. When courts restrict medications, we prescribe mandate treatment modalities that don't fit client needs or require us to report information that breaches therapeutic trust. We cannot do our jobs effectively. This bill removes those barriers while maintaining appropriate accountability. Finally, the access provisions are essential. Treatment must be available in the county where someone lives to maintain family connections, employment, and support systems. Telehealth options increase accessibility. Eliminating cost barriers ensures equity. The requirements that every county establish a diversion part addresses the current geographic lottery of justice. Some will raise concerns about eliminating charge restrictions or allowing violent felonies. The evidence does not support those fears. When puts communities at risk is cycling people with untreated mental illness and addiction through jails. What enhances safety is connecting them to effective treatment and support. I have witnessed the transformative power of genuine treatment. I have also witnessed the harm of coercive, punitive approaches disguised as help. This bill represents a paradigm shift from punishment to healing, from one-size-fits-all to all individualized care, from abstinence only to harm reduction, from guilty until proven recovered to innocent and deserving of help. Thank you.
Thank you so much. I'll start with you, Dr. Slattery. How does incarcerating people for relapse undermine recovery efforts, and why is it important for the bill to prohibit incarceration for clinical decisions?
So when individuals come to us as a provider, we inform individuals that recovery is a journey. And during that journey, there's going to be relapse. So why are we contradicting that? By telling them that the journey that they were supposed to be on, addiction is a disease of the brain. So we treat medical with a relapse. People with any type of medical diagnosis, like diabetes, they know there's going to be some form of a consequence. So when we're punitive in our actions, all we're doing is telling the individual that they're wrong, and they're going to be placed into a situation that's just going to exacerbate their mental health.
Thank you. Mr. Nathan, you mentioned at the end of your testimony that beyond expanding court treatments, we need to invest in the behavioral health system. Could you go into detail about that?
Sure.
And what specific areas should legislators prioritize in funding
Sure, right.
to ensure the success of this legislation? Okay, I'm
That's
done
right.
now.
Right, it goes without saying, right, if you have more people able to access treatment courts, it could present a capacity issue on the behavioral health system, right? The more people that would be going through that, the more treatment teams that are needed. So there is a need for investment in the behavioral health workforce, whether that's in the form of higher targeted inflationary increases, different ways to license those individuals, better ways to grow that workforce.
What do you mean by different ways of licensing individuals? Because there is the dual license
Right.
efforts now.
There's some issues out there that NAMI typically doesn't get into because we don't represent a lot of service providers, but that people have brought some of those issues to us in terms of how people go through training and things like that. We aren't necessarily for or against that. I just bring it forward as an example of at what rate do we increase this, which would definitely help New Yorkers, and are we increasing the rate of new clinicians or access to new clinicians? And those rates kind of have to match up, right? So.
Okay, thank you.
Yeah.
Ms. Justina, thank you again for your testimony and your story. As somebody who's been at Rikers, been through the system, what can you say are systematic changes that would be necessary to transform these units into effective treatment environments? If we never do, we're going to get the bill done. But please tell me, what are some suggestions that you feel could be better done?
Definitely more mental health treatment, but there is already mental health treatment on Rikers Island. But as I stated, people are not able to receive that treatment, and that's why the Treatment Court Expansion Act needs to be passed so that people can be able to receive treatment in the community, because in that kind of setting, they're not going to be able to get the treatment that they really need.
Thank you. All right, that's all for me now.
Thank you. Well, I want to start by commending you, Justina. I hope you don't mind me sharing. Justina and I went to high school together, and I couldn't be prouder to see what women we've become, and that we are now here sitting across from each other trying to bring real change to the people who need it the most. So thank you for your bravery. I can't imagine that as a licensed social worker, it must have been easy to blow that whistle. I myself have visited Rikers on many occasions where I heard complaints of people not receiving their medication for 3-6 weeks at a time. I witnessed a man attempt to take away his own life. It is truly an undesirable place, even for your worst enemy. And so I want to ask, why do you think it happens? Is Rikers Island, is the system provided with the medication that is needed? Are the delays in treatment deliberate or necessary because of the lack of providers and medication? Or is this part of the punitive mentality and practice that exists in the system?
Thank you. So it is definitely because of the punitive mentality, because there is treatment providers on Rikers Island and there are medications, but when somebody acts out, and it doesn't have to be in a violent way, for example, just disrespects an officer or makes the officer feel uncomfortable, the officer then will lock the person in their cell, and because the medication comes on the unit and people have to line up to get their medications, once somebody's locked in, they're not getting their medications, and they already have a serious mental illness, so being locked in a cell and with a serious mental illness on top of that, they decompensate so quickly. And this happens in every mental health unit on Rikers Island. This wasn't just on my units, and it happened every day. There were days when I went into work and I had 15 patients locked in the cells. And the officers couldn't tell me why, because they never documented this, because this is prohibited. So they would say, well, I don't know why they're locked in. I wasn't here over the weekend. And I had situations where I was able to get patients out of their cell and they did well for a week. They took their medication every day, and then something happened over the weekend with an officer, and now they're back to being locked in, screaming, banging, tearing up their mattress. And like I stated, often it resulted in them smearing feces, and they would sleep in these cells and they would wake up and these cells were filled with flies, and that's where they ate their 3 meals a day. I've never experienced something like that ever in my life. And I live in New York City. I ride the train every day, and I've seen homeless people live on the streets, but I've never witnessed people live like this in this kind of condition. And these are people with mental illness, and these are specialized mental health units on Rikers Island where we're told this is where people can receive mental health treatment, and they come out worse than they came in.
Thank you, Justina. Very quickly, in the interest of time, Dr. Slattery, with the bill, we are trying to allow eligibility or leaving eligibility to the discretion of judges, the person's suitability for treatment court. But, you know, courts have always been designed from the lawyer's perspective. As a behavioral health expert, as a clinician, if you had the opportunity to design a court system or a system of accountability for wrong or bad behavior, at what given point would be, or what would the ideal point to inject clinicians be?
So I think from the get-go, to have treatment court work properly, whether it's mental health or an SUD, we need to be part of the process immediately. Because if we don't work as a team all together, then there is deemed going to be failure, because the individual in front, you're going off of a piece of paper. You don't know if the person is substance-induced or mental health-induced, number one. So you don't even know who's sitting in front of you truly understands their behaviors. We also don't know, because at this point, cognitive abilities aren't even talked about. So clinicians really need to be working together collaboratively with the court team.
So in a perfect world, would you even say clinicians should be present at arraignment?
Yes, I do. I absolutely do.
Thank you. That's it? I'll need my follow-up time later. Okay. Thank you, Senator.
Yes, I do. For Dr. Slattery, in your testimony, you used a term of medication barriers, where individuals who are before a judge. Can you just expand upon that and give me a little more insight to what that looks like?
Two different barriers. One is medication-assisted treatment. We're involved in a lot of courts throughout the counties because we're obviously a large organization. I've seen court systems literally stop individuals from being on certain medication-assisted treatments, whether it's dose or whether it's being duly diagnosed because for pain or anything else. I also have seen psychoactive drugs, whether it's stimulants, be halted because they don't understand the individual in front of them who maybe has a diagnosis of ADD, ADHD, needs that. So then their behaviors get exasperated. So when I say medication barriers, it's not just for opioid use disorder, it's for mental health. And if the education and the training's not there, so if the clinician is able to speak to the judge or speak to the treatment team and say, this is the reason behind this individual's diagnosis and medication for them to be successful, then the collaboration won't work. They're
And-
deemed for failure.
And as a follow-up with that, so these are judges outside of the types of courts that we're talking about today. Could be a county court judge, you know, based on whatever the offense
Yeah,
is.
we're provider of all court systems, so I made it as.
And so what do you know, what's your experience as it relates to the information that a judge will receive who can make this determination, no, you're not going to take that medication, which could be, you know, completely contrary to what you and your folks feel. How does that work out?
Because what I've seen is there's a system in place where the court system goes off of their psychological evaluation with their paperwork, and that it might not include treatment providers' paperwork. So there's a bias. They're not connecting the two treatment the paperwork. That's one information. The judge doesn't have the information complete. That's the problem. It's not the judge's fault. It's the fact that we have a system that needs to be a workflow that needs to be done collaboratively. So everything is siloed. From what I've seen, and it's not all, I'm not going to say all, but I've seen where it doesn't work is because they have a silo happening, like the example before with the ADA, where there's information that's not being put out into the courts for the judge to be able to make a reasonable decision and an observation.
So the factors that go into this disconnect between a clinician and the judge, you know, what are the factors that are these? Is this evidence-based? Is this financially based? You know, I mean, like where all of a sudden, you know, someone will say to the judge, you know, Your Honor, this particular individual should not be taking this particular medication anymore. And if there's a contrary opinion, how does that get fleshed out, or does it?
Well, I think when you're a good assessment process, so your workflow is going to have a specific comprehensive assessment on part of that. In there, you'll see certain diagnosis. There is medication that needs to be part of that diagnosis. I'm not saying everyone should be placed on medication, but the individual coming there is someone who's been decompensating for a long period of time and is not stabilized. So I wouldn't say it's a financial barrier. The financial barrier could be that they didn't have insurance and they haven't had proper assessments. So I also think it's also a clinical barrier because you have one person with their interpretation. Remember, we're only as good as the information we receive from the individual. So if the participant is not buying into the court person giving them their evaluation, again, you might think that person's just being oppositional. And so right away, they're not even looking at the full mental health picture.
Okay, I mean, and just, there is an individual that I have known for over 10 years who has been advocating for her son, who was in DOCS under Matt. He's come out and had those types of challenges, being able to continue with that particular treatment program. And this is, I just got an email from her the other day. Hadn't heard from her probably in 2 years. Something's going on again, you know, with her son and his treatment to keep him level. And so, you know, here's something that's been going on for all these years. So I appreciate you saying that, because it's given me the opportunity now to know a little bit
just to
more
add
about
one thing to
this.
that, if I
Yep,
may.
Please, you can, of course.
Every 7 years, our body changes. Every 7 years, medication changes. People forget that. What worked before might not be working now. What didn't work before might work now. That's why we all have to talk together.
Yeah, and thank all of you. Appreciate it.
Thank you so much. Harm reduction has obviously been mentioned today, and in the testimony given by OASIS this morning, they also mentioned the benefits and the stats proving that it works. But can you speak to the difference between harm reduction and abstinence, and how treatment courts can better incorporate harm reduction into their models?
So abstinence is all or nothing. If you have an individual in front of you with a serious mental illness or addiction, all or nothing right off the bat does not work. So if abstinence is going to be the set, then there's not going to be a successful outcome for someone in the beginning phases of addiction. Harm reduction, it's not saying you can do this and be okay and keep relapsing. What harm reduction works is it looks at, let's be person-centered, let's give tools, evidence-based tools that are going to work to reduce your use. And people don't understand the word reduce, meaning you're using this, we're going to go to this. It's a process. So maybe the length of stay in treatment court changes, or maybe the design of your workflow needs to change. But that harm reduction interventions, it's placed in their plea, in their contract, say. And they have to follow those interventions. That's more evidence-based. But if it's abstinence only, then SAMHSA, NAMI, NIDA, everyone's going to tell you it does not work.
What about co-occurring disorders? How have we been able to best address that right now? And if it's not being addressed properly, which I don't think it is, how can we see co-occurring disorders be properly assessed and treated?
I think we have to first state that what is the primary diagnosis needs to come out of the language. If we just look at primary diagnosis and don't look at all the other components, DSM-5 in 2017 changed that language, but the treatment courts, treatment providers hasn't. They still look at the person with the primary diagnosis. So co-occurring is working with obviously the mental health and substance use, but not saying you have an opioid use disorder. Mind you, you still bar bipolar 1. And that's where to be truly working with co-occurring, is the individual substance induced or mental health induced? And really truly understanding who is in front of you and getting that type of treatment. That type of co-occurring treatment and that type of philosophy will work better than saying mental health and SUD.
Thank you. Senator?
Thank you, Senator. Nadia, I can't tell you how much we'd like to see cases in Queens. And I'm wondering about what your rate of placement, particularly as it pertains to employment and in terms of reentry. I'm putting my labor committee chair hat on. How many more, perhaps it's a diversity of opportunities, more opportunities. What's needed to improve reentry placement within employment for folks?
Yeah, thank you for the question, Senator, and we would also love to be in Queens more. So the rate is going to vary pretty dramatically by our different ATIs. So the Nathaniel Act ATI that I talked about before, we do see employment increase. Folks tend to enter the program, I think it's 4% are employed. It's very low. And at the end of the program, we've doubled that, but it's still quite low. It's 8%. And these are mostly folks with pretty serious and profound mental health challenges who probably are not always going to be people who can be full-time employed, right? These might be individuals who also qualify for SSI, as an example. But our Nathaniel Community Success Program, which is for people with mental health challenges, but not necessarily the same depth of challenge, sees much stronger employment. I think there's a couple things that we need. One, I mean, pre-plea is just super helpful, right? Because as soon as someone has that charge, that or a conviction, that is going to immediately shut off certain employment options.
I apologize because I'm going to want to sneak in another question to someone else. What specific industries do you think we need more opportunities?
Yeah, we do a lot of work with construction. So I think construction, there's a ton of opportunities.
There's good pathways. With the laborers.
Exactly. There's good pathways there. I think we would love to see other employers take more of a focus in this area. Unfortunately, some of the easiest places for folks to get employed is like an Amazon warehouse. It's not a quality job.
It is definitely not a quality job. Those warehouses are designed for the boxes, not for the people.
Yeah, and they pretty much view the people as about as disposable as a cardboard box.
Modern day sweatshop.
We would love to have closer partnerships with employers. The other thing I'll say, my colleague Nicole testified earlier, we employ a lot of peers in our programs, but we'd love to open up greater career pathways, both for peers to be able to move into more supervisory positions.
I'm interested in continuing this conversation with you offline to see how I can help on the labor side, but I'm going to sneak another question before I get in trouble with Senator Fernandez. Ms. Robinson, Laura, I wanted to ask, you testified that in some areas, treatment court seems much more restorative, a much more accepting atmosphere. Do you find that that's true in more homogenous counties? How does diversity or perhaps even the lack of language access play into success rates or successful outcomes in treatment court?
Absolutely. Thank you for the question. Just kind of like thinking about it again, right now being in Buffalo, we have one of the original opioid courts that exists, which is pretty incredible. But we can also see that disproportionately it serves majority of white individuals that go through that process of an alternative to incarceration or diversion.
I understand.
Correct, much lower. I think in 2023, a study was covering that I think any white candidate to go through an alternative to incarceration was like twice as likely to be admitted into an opioid treatment court than anyone else, which is really substantial to looking at the engagement or kind of being able to see where that offset exists for people of color, indigenous, BIPOC, and population, which is super harmful. So,
thank you.
Of course.
Nathan, I'm out of time, but thank you for your testimony.
Thank you. Senator Rollinson for some follow-up.
Yep, just quickly, thank you, Madam Chair. I haven't used that term today, but you are chairing this, so.
It's okay.
This is for Nadia. You used the term ATI. And coming from Dutchess County, our county in the 2000s, and I say this really, had established the gold standard for alternatives for incarceration within the Dutchess County Jail, now Dutchess County Correctional and Transitional Facility. And what's happened, and I just, in the 3 minutes that we have here, or actually 2 minutes and 26 seconds, is that because less people now are going into the facility because of different bail standards, use that term, that they're not getting the services like as soon as they go through the door. There was an evaluation made, probation was in there, getting people out on EM, other ATIs. So we've seen a larger population of people not going in and not getting the services that they were, at least they were offered, as also sometimes part of, we're going to get you out, probation will get you out, and then you're going to be able to, you have to do this. You know, somewhat very similar to what this bill actually is trying to do. So just what, you know, just what has been your experience, maybe a little bit different down this way, but I know it's challenged us a little bit in the ATI world and like pre-services, you know, pre-plea, getting yourself, you know, moving in the right direction, which will ultimately help you when you go to court.
Yeah. So I should say two things. One, all of our programs can be both an alternative to incarceration or an alternative to detention. So we can take people, you know, at a pre-plea status. But I should also say we are actually the supervised release provider for Manhattan. So, you know, I think both passing the Treatment Court Expansion Act to really open up access to treatment courts, because we primarily are in Brooklyn, the Bronx, and Manhattan, and we've seen our volume just only increase over the last several years. But also really looking at supervised release as a way to get folks into programs and referrals. And we really view, you know, a lot of folks in our supervised release programs, I want to be clear, don't have a diagnosis. They're just people who need to do some check-ins and complete their court case. And we want to support them in that, and we don't want to mandate them into programming that they don't need. But we also know a lot of folks are coming in with mental health challenges, with unstable housing. And so we really view our supervised release program as a front door where we can connect those folks to our mental health clinic. We can connect them to our employment services. We are just about to open a 32. It's been a very long process, which we would love to see that be smoother. But soon we'll be able to do that in-house, but certainly we've been connecting folks to substance use services for a long time. And so, you know, I think rest of state really looking at how do we build a more robust pretrial system so that folks can get connected to care.
Thank you, appreciate it.
Yeah.
Thank you so much. Next panel. Have a great day, everyone. All of them are clappable.
They're all clappable.
Oh, I love Dr. Slattery's outfit. The skirt and blouse. Yeah. Beautiful.
was good being with you both today.
It was.
It's good to see you
see
both,
you.
really. Yeah.
Thank you.
Good to be hanging out with you.
Oh, this is the Dr. Skip panel.
Wait, let's take a quick selfie. The senator's here.
Yes, please, let's do that.
Get over here, guys. Right? Perfect on that.
See you soon.
All right, thank you. We'll start at this end. Please introduce yourself.
Yeah, thank you. Good afternoon, everyone. I stand before you to the glory of God. I'm honored to be here. Senator Rollison, you leaving?
I gotta get trained.
It's a pleasure.
Yes.
I'm actually a resident. I'm actually a native from Newburgh, New York. So I'm definitely
Love Newburgh.
glad to have you here.
Yeah,
You know,
yeah, I'm
to
glad
hear
that I-
about this act. It's very important.
And I look forward to following up with my two colleagues and friends too on this.
Absolutely. Hopefully, we can expand the Hudson Valley. All right. We'll touch base.
Yes,
later.
please. Thank
All
you.
right.
All right,
Thank
take
you.
care, everybody.
Stay
Absolutely.
connected. Thank you, Senator. You get an applause too.
Unprecedented.
Absolutely.
Yeah, see, we
Congratulations.
appreciate the minority here.
Right. And so here I am. I stand before you by the grace of God. My name is Charles Corbin. I'm a peer advocate. I'm a peer professional in the human service field, but I'm also someone who has lived through the criminal legal system and understands the struggles that bring people into the courtrooms. I've been through the courtrooms. I've been there for people before the courtrooms, during and after the criminal legal system, and I understand these things. And so my story is a testimony of the transformation that's possible. And this is possible when opportunities, accountability, and support come together, right? So I'm not, who I once was. Who you see here today is not a full, description. If I could tell you my testimony, it wouldn't be enough microphones here.
Well, luckily there's time for testimony.
Yeah. Yeah.
Down the line with names and.
Well,
Yeah.
since you kind of started, continue
Okay.
with your 5 minutes, and everyone will introduce and then get your 5 minutes.
Okay. I can just give a brief. I started an agency called the Proper Perspectives for myself. I've been working in the human service field for some few years now. Upon my reentry into society, working with Exodus Transitional Community as a clinician, a housing director. I went, through all the way on to doing peer support. I've worked with SUNY, Office of Higher Education and Prisons, also to advocate for higher education for individuals who are justice impacted. I've worked with the U.S. Attorney's Office as a credible messenger for One Pill Can Kill, a campaign that seeks to teach and prevent youth in the schools in New York City, dealing with substance use, vapes, gummies, X, Y, and Z. I've also worked with certain agencies like counseling in schools to reach clinicians that work with youth dealing with substance use in their schools in New York City. And more recently, I just transitioned with the Department of Health and Mental Hygiene with a group of peer advocates. Now I'm a peer supervisor for a court-based program that OMH has funded. These are just some things I've been doing since reentering, but a highlight of who I am is an advocate for individuals with serious mental illness and substance use disorder, especially with the Bronx Opioid Collective. My reentry, I'm from Newburgh, New York, but my reentry, I landed here in the Bronx, still coming from the Federal Halfway House. I was met by peers who supported me, and I admired their contribution to my reentry. Particularly one gentleman named Nasir Jones, who wrote a book called Black Salt for White Eyes. He encouraged me to build a support system around individuals with lived experience. And that's where I found my way in New York City, in the Bronx. And I did so with Samaritan Villages, the Acacia Networks, and all the agencies in the Bronx, and continued my work to advocate. And so that's just a little bit of who I am and what I've been doing. And I'm gonna pass to Skip. Love the Bronx.
As a Bronx resident, I salute you.
Yeah.
Hello, everybody. My name is Helen Skipper. I am the executive director of the New York City Justice Peer Initiative. I want to be clear about why I'm here. I'm here as a proponent for the Treatment Court Expansion Act. I'm here as someone that would not be sitting here if I wasn't finally given an alternative to incarceration program. I'm also here for those who are still caught up in the system who are not being given that access. Let's be clear. I sit here today after 25 years of going in and out of Rikers Island, after 25 years of growing up on Rikers Island. I started when I was 17. Yes, I know I look a day over 18. Actually, I'm a little bit beyond that. But for 25 years, I went in and out of Rikers Island, suffering from an unchecked drug addiction, a visible drug addiction, suffering from an unchecked mental illness, suffering from homelessness. Every time I got arrested, every time I was criminalized for a behavioral health concern that is actually a public health and not a public safety concern, I was thrown up under the jail. But yet here I sit today. And let's talk about why I sit here today. Today, I sit here as the vice chair of the New York City Board of Correction, yes. After growing up on Rikers Island, I have transformed my lived experience to professional lived expertise. I sit here as an adjunct professor where I teach peer support competencies at LaGuardia Community College. I sit here as a nominated member of the Council on Criminal Justice. I sit here as a doctoral candidate, soon to be in fall of 2026. I'm sorry, after 6 years of full-time school and full-time work, I needed a break. I sit here as a recipient of a bachelor's degree with honors. I sit here as a recipient of a master's degree in criminology with distinction. I sit here as a published academic author and author otherwise. But more importantly, I sit here because my lived experience put me here. And let me just say this. If the Treatment Court Expansion Act was in place when I came through the system, I wouldn't be sitting here. I'd be sitting up there. But let me also say this. It does not
We have a
mean,
convicted felon as president.
it does not mean I won't sit up there. If you know me, you know that I am moving and I will sit up there. Lived experience is professional lived expertise. We cannot get to where we are if pathways for support are not installed. And I heard someone testify and talk about supervised release. I heard somebody talk about how people don't want to accept a mandate for recovery, and that is very true. That is very true. When you've come in and out the system as much as I have, you know that accepting a mandate for treatment is a setup for failure. You know that you can do 18 to 24 months in a program and suppose life shows up and something happens and you experience a relapse. You know that that 18 to 24 months that you spent in the program is not reflected in the fact that you pled guilty to a crime that could give you a 2 to 4. So you could spend 18 months of your life in a program, relapse, and then have to do that whole 2 to 4. So those 18 months are dead. That is not the way access to recovery should be. Recovery is individualistic. It is not when the government, the courts, your mama, your kids want you. It's when you are ready. And in order for us to be ready, we need the appropriate supports and pathways. So I grew up on Rikers Island. I went back and forth to court. 9 times out of 10, I was denied a program because I had failure to appears and warrants. Why did I have failure to appears? Because if you arrested me visibly addicted and you gave me a piece of paper by the grace of God saying, oh, you can go, just come back on this day, do you really think I was coming back when you released me with no supports, no nothing? And supervised release, a program that I started peers working in the criminal system with, is a very beneficial program because that takes away from that. But looking at treatment court, DAs are gatekeepers. Every time I went before a judge, again, visibly addicted, I was denied access. Why are we denying access for something that someone needs? Again, criminalizing behavioral health, which is a public health situation and not a public safety situation. You threw me up under the jail. I never committed a violent act. I might have stole something. I might have jumped over a turnstile, but I never committed a violent act. And everything I did was to fuel my drug addiction, which if we use a trauma-informed lens, which is peeling back the layers of the onion and just figuring out who is sitting before us, we would understand that a lot of these instances of criminality are committed by someone who is suffering from an addiction, who is suffering from unchecked mental illness. And I want to call on the city and the state, because guess what? We are denizens of the city and state. It is on you to protect us, to give us the appropriate supports, which you do not do. Yet you want to throw us under the jail. For 25 years, I did that. When I finally got a program at the end of my 25 years, look where I'm at now. Imagine everyone else who would get this type of support. Look where they could go.
Thank you so much. We'll
Thank
get
you.
into that more. Thank you.
No hot mics.
Great. Thank you, Senator Ramos. Thank you, Senator Fernandez. I'm Daniel Addis. I'm the Senior Director of New York Legal Policy at the Center for Justice Innovation, which handles the clinical and case management operations for two of the most successful court models that you've heard a lot about today and on which this legislation is based, the Brooklyn Mental Health Court and the Felony ATI Court in Manhattan. Under the tremendous leadership of Judge Demick and Judge Bybin, these courts have shown that we can go beyond the current Article 216 framework to support more people in the community while holding them accountable. Between those two courts, over 2,000 people have been safely diverted so far, over half of them originally charged with violent felonies. But even in resource-rich New York City, people who seek treatment outside of the Article 216 courts wait for months or more to be placed into treatment. Given significant barriers to entry, many people decline to pursue these alternatives and instead choose to negotiate jail or prison sentences that do little to change behavior, put them on the path to recovery, and nothing to impact long-term public safety. In other parts of the state, people simply don't have access to these kinds of courts. That's why CJI fully supports the goals of the Treatment Court Expansion Act to increase the number of people and the kinds of behavioral health conditions that are eligible for Article 216 diversion. Now, before I turn to some of the more challenging policy questions, I am a former public defender and a former legislative staffer, so I do want to talk about law, but I want to start with something that I've learned from some of my CJI colleagues who do the work of running these programs day in and day out. And I think it's actually more important than what goes into the bill. And here's why. No matter how many people are eligible for diversion under the law, you can't divert them if you don't have clinicians to assess their needs. You can't support them in the community without case managers and peers to help them along the way. And for those who need a place to live while they engage in treatment, you can't get them out of jail or off the streets without a bed in a facility that is equipped to meet their needs. Even in New York City, there is one residential program that is equipped to treat individuals with serious mental illness, and none for people diagnosed with SMI who don't have a co-occurring substance use disorder. Resources for people who are neurodivergent or suffer from the neurodevelopmental conditions are nearly non-existent for the forensic population. I'll pause for a moment to acknowledge the testimony earlier about the young woman with a nephew. Even if the Treatment Court Expansion Act was in law today, I'm not sure that that young man would be in a program because there aren't programs for him, and we need to invest a significant amount of attention and resources in creating those kinds of resources for that population. And even for everyone else, slots in existing treatment courts are severely limited by the number of case management and assessment staff that existing funding can sustain. The expansion of these services implicates significant logistical challenges involving workforce development, medical coverage, housing, transportation, and more. And if service providers are not funded to meet the complex needs of the individuals they aim to serve, participants won't be successful and the model will not be sustainable. We urge the legislature and the governor to look beyond the four corners of the bill to the availability of these resources for the justice-involved population specifically, especially outside New York City. Now, turning back to the procedural questions, I want to focus on the two, I think, critical divisions that remain about the legislation, which has progressed really far, and to the credit of the advocates and the unified court system and the sponsors of the bill. But first, I want to say that we fully support eliminating most categorical exclusions, including charge and criminal history. That doesn't mean everybody should be diverted, but judges still retain the authority to reject diversion when it's appropriate. And the decision ultimately should be informed by a clinician who is trained to evaluate whether someone can be safely diverted. And that's true even when the case initially appears to be too serious. I can't tell you how many times I've seen DAs and judges say, I will never offer diversion, and then after they read a well-written assessment with a well-prepared treatment plan, they change their minds. As to the plea question, which I think is one of the more vexing ones, and I think both sides, although only one side is here today, we need to balance the need to preserve judicial discretion against the true chilling effect of plea bargaining. On the one hand, judges do believe, and I think it's reasonable, that the plea structure has worked for them and that it's critical for accountability between the court and the participant. The courts we operate use a plea-based model, and as I said before, we've seen it work for thousands of people. But it is also clear that the plea negotiation process and the possibility of getting sentenced to prison time, as you've heard today, have a chilling effect on people's willingness to engage, and that does nothing for the rest of us. So we offer a middle ground, and I'm going to go over just a little bit, but I think it's important, and it's in service of getting this bill across the finish line. And the suggestion is to create a presumption. I know that there's a distinction between violent felonies and nonviolent felonies. Frankly, I'm not sure how much that relates to somebody's likelihood to complete a program, but I think a presumption that somebody who's charged with a nonviolent felony gets into pre-plea treatment will get them into treatment faster. And I think if judges, though, have some discretion in certain specific circumstances, a rebuttable presumption, when, let's say, there's extensive warrant history recently, or somebody's failed the treatment program before, or somebody gets arrested a few times while engaged in judicial diversion, I could see ways in which a judge can say, for this individual, I'm going to require a plea up front. But that discretion is absolutely critical. And the last thing I'm going to say, the last procedural point, and because I don't think it's been discussed yet, is the idea to give judges discretion to go down on the mandatory sentence. Because I think the biggest problem, the biggest opposition to somebody who might want to engage in treatment is what the sentence is going to be. So if judges had the power to go beyond the statutory minimums, the impact of the plea will be significantly less. And I hope that those two suggestions of a way to move forward might be an opportunity to get this bill across the finish line. Thank you very much for listening, and I really applaud everyone who's testified today and all of you who are working in support of this bill.
Thank you.
Hi, good afternoon. I'm Zachary Katz-Nelson. I'm the Executive Director of the Independent Rikers Commission, often known as the Lippman Commission, after our chair, former Chief Judge of New York State, Jonathan Lippman. Our commission was appointed by the City Council to look at Rikers and trying to figure out how do we close it as soon as possible and how do we come up with something better. How do we have a system that actually meets people where they are, that provides safety, that provides treatment. Our commission is made up of 40 civic leaders from across the spectrum in New York City, from people who worked in corrections to people who are formerly incarcerated, people who work in the healthcare sector, to judges, lawyers, people who worked in corrections for decades, and really came together and put out a blueprint in March of this year to really lay out a unanimous blueprint, I should note, to lay out how do we move forward. And one of the key issues is how do we expand opportunities, maximize opportunities for different outcomes. And the Treatment Court Expansion Act is an example of how we can do that, right? How do we maximize eligibility? How do we maximize the capacity of these courts? It's just one tack, right? One of the pieces of all this, but one we have to take. If we look at Rikers right now, the stats are horrendous, not just the human side and the deadlocking we heard about that Justina's talking about, the awful, awful situation, but even just on the public safety front, 47% of people who are released from Rikers who have a mental illness, right? More than half the people have mental illness. 47% are back in Rikers within 1 year. So it's not just rearrested, they're reincarcerated within 1 year. Like, that is atrocious on so many levels. And as Skip was saying, right, she lived that, right? People live that, and it's helping absolutely no one. And people who end up in that situation, there have been countless inflection points in their life where they didn't have an opportunity that was given to them. They didn't have an intervention. And so it should never be the case that it's only now when someone's been arrested, when they've maybe committed a crime, when someone's been harmed that we're intervening. But this is the inflection point, the opportunity, the intercept point that we have now. So how do we maximize that opportunity? And I think the bill is really aiming to do that. hopefully with suggestions like Dan, others, we can actually move forward and find resolution, get the law passed, work with the courts, get this done. And I think I just want to talk about a couple of things that have been alluded to, but the idea not just about there have to be the treatment capacity in the community to actually meet people's needs, but we also need to start thinking about the staff, peers and others who are going to ultimately provide that care. We need that pipeline to be built, start to be built now, because we don't have enough staff to actually fill the vacancies that exist today in the existing services. We're going to want to expand. We need to expand the capacity statewide for this type of treatment. We need clinicians. We need peers. We need all types of support workers, social workers, doctors, nurses, everybody in this. And we don't have a clear plan as a state, let alone as a city. How do we actually achieve that? And I think thinking from a labor perspective and otherwise, what are the things that we can start to do to incentivize people now to enter these fields and to stay in these fields? Right? Where do we build the training centers? Can we put the training centers even in hard-hit communities in New York City and otherwise that desperately need jobs and desperately need opportunity, and get people moving into an excellent career and hopefully a good paying career down the line? But when you start, I know you're doing work on this, but like, how do we try and come up with a comprehensive plan now so that even if we have funding available, which we don't yet, for the services we need, for supportive housing, for residential treatment, for outpatient treatment, whatever it may be, that we actually have the people to staff it and provide it. And so it feels like that piece, this bill is not being asked to grapple with that, but if it was going to succeed, we're going to need it. And so I hope that we can work together to think 5, 10, 15 years out from now, and how do we start to build that capacity today?
I truly agree. We need to start building that infrastructure now. One of the quickest things that I could say about how do we get people into this work is to pay them better, make this be work that is sustainable. Because too many times I've heard and seen in my visits to different clinics how there is a particular employee there that is loved, that is a peer support advocate, that is someone that has helped so many other people, but then when you look at their life, they can't sustain their life with this work and they have to move on to something else, or they go to a different area, and then that disrupts that patient's journey and progress, because now they lost somebody that they've trusted, that they can believe in and rely on. So where that starts, maybe a better pay, and that's definitely a conversation that I want to continue. But to the peer point, obviously I mentioned my bill before, and I do believe that we need to open up these barriers and to connect people to those that have lived it, those that know, those that can really connect in a different way than even someone like me can. So my question, let me see, where was I going with this? Well, youth. You mentioned youth, that you address our youth here. Can you speak a little bit more about how we can connect to our youth? Because when we talk about preventative care and how to stop someone from even trying, how to deter a student from picking up a vape, what have you seen to be successful as a counselor, as a peer support advocate, to really get to our youth?
And so I'm glad you asked that too. Youth are difficult, because they have their own mind. And sometimes that old model of scared straight doesn't work with them. There's never a cookie cutter way to deliver peer support. But meeting someone where they're at, understanding, showing them that you understand, you've been in the hallways, you've been in the bathrooms, you've seen the smoke. These intersections of peer support is different, and I sound like that's what your bill that you just passed, that is going to really afford that in the streets, in the police stations, in the schools, peers in different places, different intersections.
Well, we got to expand on it. My bill was mainly just for our incarcerated facilities, to remove that barrier that if someone had a conviction in the past, they cannot enter a facility again.
And that's one of those intersections, though, I'm speaking about, as well as the schools, right? The schools, the prisons, the police stations, not just in the clinics. Peers have to be in the community. I know peers in the opioid collective that drive around in their cars, picking people up, bringing them to treatments. There's different intersections of peers. And so being in the schools is one of those intersections where we have to build off of lived experience, but not in a scared, straight way, but meet the person where they're at. Being humane with the youth. Like, the youth are real. They have voices. Every generation isn't the same. So, like, understanding, like, you're a picture of hope, but you don't determine. There's no cookie cutter way, because there's so many social factors that created you who you are today. But just showing yourself as a reentrant, for me, as a reentrant citizen, as a sober being still in recovery, as a person who still wrestles with mental health, who grew up in the same circumstances. There's things that they're scared to talk about, but being present, being available before it happens. That's the preventative piece. Being in the schools before it happens, being accessible.
So we need some investment into these programs
Absolutely.
for schools. But Ms. Skip, how does peer support help break the cycle of reincarceration in a way that traditional models have not?
So as the executive director of the New York City Justice Peer Initiative, I built that initiative based on my own lived experience. Because all the time that I went through, I never had a peer like me, someone who had behavioral health concerns and also impacted by the criminal justice system, who could show me just by walking in front of me, just by talking to me, that there was hope, there was possibility, that recovery, that second chances, that all of this is there and we can get it. We need to take that. We need to take that hope dealer mentality. We need to take that change agent mentality that we peers have. And we need to push it in places where people need it. He talked about the schools for the youth. How about the community? How about reaching people before they even get impacted or intercepted by the criminal justice system? Peer support is about being there, fighting that good fight, and coming out on the other side. By us standing upright and being able to talk our truth, to be authentic to people, it shows people that it is possible that you can. Look at me, I thought I smoked enough dope to get to Columbia and back. I did.
University, right?
Yeah, okay. Back in the days, but now I'm here under a different aspect. But like I'm saying, like seeing positive role models, positive mentors, because that's what peer support is. It's in a mentoring capacity, showing people that I can do it, so can you. Let me assist you, because one thing about peers, we don't tell people what to do, but we use our own experiences, we use our own way of living as a model to show people that it can happen for them. I hope
Thank
I
you.
answered your question.
No,
By the
you
way,
didn't.
thank you for inviting me. Forgot to say that. You know, I just lit in with both barrels, but thank you.
No, thank you so much. I'm done with my time. We can continue.
Okay. Oh, thank you, Senator. Well, to the future Dr. Skip. Let me say that I've been in awe of you for the years that I've known you and that I've seen you advocating in the halls of Albany, and I thank you for your brave testimony. You have not only been a champion of treatment court expansion, but you were also a champion for clean slate and many other measures.
Yes, ma'am.
Given your lived experience and your expertise, would you say that aside from Clean Slate and the Treatment Court Expansion Act, when enacted, what other things can the legislature do to ensure that we are covering all the voids or filling all the voids that are left by people impacted by the carceral system?
You need to offer us inclusion. A lot of spaces and places are closed to us because we are impacted.
Like which ones?
I want to say me working in a carceral facility, a lot of times that is a hard, long road that I can't navigate. Because let's be clear, let's look at the stigmas and barriers of having justice impacts. Let me give you a brief story. Can I give you a brief story?
Very brief.
I am an ED. I make money. But if I go down in the train system and my Metro card doesn't work and everybody else is going through the turnstile and I decide to go through the turnstile and I am stopped because of my lived experience that spans 30, 40 years ago, I'm going to jail. And it doesn't matter whether I have money or plastic in my pocket because of my background. Mm-hmm. Let's remove these barriers that our background puts before us.
Okay.
We need inclusion. And I don't mean just having us have a seat at the table. If you've heard me talk before, and I know you have, Congressperson Shirley Chisholm said, if they don't give you a seat at the table, bring a folding chair. Me, I'm too jiggy for that. I'm not dragging a chair anywhere. Every
You
space
should just make your own table.
every space I go in, I am the table. You need to come sit with us. So as you want to make changes to these systems, sit with those who have navigated these systems, who have come out on the other side. We have thoughts, talents, expertise
Absolutely.
that everybody else
No, and
doesn't.
I want to thank you. I want to thank Charles. You know, I'm a big believer in peer support, incredible messengers all around in different
Thank you.
spaces. I only resent, and I want to say this on the record, I only resent that there are very few resources in terms of peer support available for immigrants in the languages that they speak. And I say that as someone who has been funding, for example, credible messenger programs in my neighborhood that, you know, may help young American, Black, Latino, American-born and or raised young people stay away from, you know, bad actors. But that's not the same lived experience in our immigrant community, and I just wish that that was seen as a worthwhile investment of our taxpayer dollars as well. And I would love to have that conversation with your organizations to see how we can support such an expansion.
Let me respond to that briefly.
Sure,
The New
'cause I
York
wanna
City
ask these fine gentlemen a
Justice
question.
Peer Initiative, we train justice-impacted individuals. We train organizations and agencies to work with justice-impacted individuals. We have also taken our training catalog and as in the midst of getting it translated and bringing in a consultant. Well, I'm not funded good enough to hire someone.
Yeah.
But bringing in a consultant to reflect that catalog in a few different languages
Yeah,
and
I need
offer
people
the
who
training.
speak Spanish on the streets talking to people.
Exactly.
That's all I'm saying.
I agree.
Eso es lo que necesito. Dan, in your experience, because I don't want us all to sound like broken records, I want you to speak to non-compliance rates and who, in your opinion and expertise, do you feel is most prone to non-compliance with program? I understand that your position is that a plea is not required, but are there specific characteristics for the person who doesn't comply?
No, I don't think that it's hard, but I know that the distinction between violent and nonviolent doesn't necessarily neatly map
Not
onto
even.
who it is. No, I mean, no. There might be somebody who's committed a violent offense, and it's the first thing that they've ever done. It's the first criminal conduct that they've ever engaged in. They're very good candidates for treatment and will have a very smooth path. There's people who are charged with violent crimes who will leave programs and not stick with the mandate. But it's on the other side too. I mean, it's just not. It doesn't neatly map to that distinction. That doesn't mean it's not a meaningful legal distinction. And so I think my suggestion is more based on, you know, is there a path for some people to get them into treatment faster? I mean, we know that there was opposition to a pre-plea model for violent felonies, and I just sort of take that and I accept that. Although I do think judges should have that discretion as well. I mean, if they think there's a bed available for this person who's charged with a violent crime, they're seriously mentally ill, it's hard to find that bed, it's open now, I think that they should have the option to put somebody in treatment now and worry about the plea later under the new statute. It's mostly a practical legal compromise to try to give judges the discretion that they're asking for, but also, you know, in response to what we've heard today, to overcome that barrier for certain other people. I just don't think there's a way to neatly map it perfectly, and so I'd rather find something that just can work and get us there sooner.
That's fair. Thank you for your answer. Mr. Katznelson, I wanted to ask you precisely about Justina Rzuinski's testimony. I mean, if the medication is there, if there are health professionals at Rikers available, and it does seem like people are deliberately kept away from the care that they need, how come there have been no repercussions over all these years? And you know, what gives? At what point, you know, what can be done about it? And I know the recommendation of the commission has been to close Rikers. I understand that. But it's not happening right now. So even in the interim.
Yeah, no, 100%. We can't wait for the closure of Rikers, which is still years away, unfortunately, to try and solve these issues, tackle them. I mean, at Rikers, even people that are not being deadlocked, and deadlocking is horrific, 40% of the time, people with mental health appointments don't make it to their appointment, mostly because correction officers are not taking them to meet with clinicians, right? So there are failures across the board here. Failures on reentry, too. I mean, last year, 1,000 people at Rikers were found eligible for supportive housing. They went through the whole process, and they were found eligible. 66 were actually placed in supportive housing when they got out of 1,000, right? So the correction department is not doing things well, unfortunately, in a whole range of areas, right? And so that's part of why the courts pulling people out is so critical, so they can go another path rather than relying on Rikers, for instance, to solve these problems. I mean, part of these issues is why the federal court is intervening and is considering, appointing a remediation manager to take over a lot of aspects of Rikers, but they're not going to do health. They're not going to be in charge of healthcare. They're not going to be in charge of this aspect of things. And I think one thing that we've tried to push as a commission is a vision for how the department can operate differently, no matter who's in charge, whether it's the federal court or New York City's mayor, is that we need to have changes now, both in terms of how staff are trained, how they're supported. I mean, one of the things that happens with deadlocking, honestly, is that officers don't have any idea how to handle somebody with serious mental illness. That's not why they joined to be correction officer. That's not the training they have. They have no idea how to handle somebody, and they misinterpret
don't receive
things.
any training.
They receive about 8 hours in the training academy.
And none of it has to do specifically with servicing people suffering with severe mental illness.
Not the
any
common
mental
officer. There was a training program that used to be thriving at Rikers before COVID called crisis intervention training for people that worked in those specialized mental health units. It completely fell apart during COVID. It was only now restarted. It used to be almost like the crown jewel of Rikers, where mental health staff and correction officers trained together as a team and then worked on those units. That doesn't happen anymore. They don't train together anymore. It's these failures of process where then you have the officers that are thrust in there, don't know what to do, and they misinterpret how somebody looks at them, how someone talks to them. They feel threatened, and they lock somebody down. And that's all that's happening. And so it's just even thinking about how do we address staff differently so they don't feel like they're completely on their own and don't know what to do. And they're making a bad choice, obviously, by deadlocking somebody, but they're not being given other options or support either. And so it feels like there's a leadership from the top that's been absent, frankly, the last several years that needs to come, and we need to start operating differently, healthcare and correction side, both.
Can I add something to that, which is it relates to the other issues that we were talking about. It's not just about Rikers, it's about what tools judges have. And if you talk to a lot of judges, they say, give me somewhere other than Rikers to put this person, and I'll put that person there, right? I mean, and DOC doesn't choose who comes in the door. So, and to a certain extent, I don't blame them for having challenge. I mean, the extent of the challenges is something else, but if we focused more on creating something that wasn't a jail to treat people who are sick, then judges would, it's an if you build it, they will come mentality that judges have, and I don't think we've been responsive to as a society. We have not created the facilities that can actually be therapeutic for these people.
And in response to the CIT question, I trained CIT with the NYPD. And you're right, there used to be a program like that on Rikers Island. And it also incorporated the voices of those with lived experiences who have been there to just kind of acclimate folks to how we think, how we go about looking at things. This is how this program is run for the NYPD. We, those of us with lived experiences, along with clinicians, train. And we're looking at it from both sides. We're looking at it from the voices of those who have been there and done that and who experienced this. And we're looking at it from the clinician's point of view on how do you adequately work with those who suffer from mental health concerns. Because no, the Correctional Academy doesn't give you that, nor does the Police Academy, but only through CIT, which, like I said, looks at it from those three angles.
Thank you so much. Well, I was going to go into another set of questions for 3 minutes, but you kind of went into it about the training that we need to have, this training that is no longer here. You said it's starting again?
It's starting again, but just on the correction side. It's no longer joint training, for instance, between the correctional staff and the healthcare staff. They no longer train together. So some of the correction officers are getting some training now, updated, more specialized training, but it's nowhere near as in-depth. And the success was working as a team, right, in those units.
Sorry, I don't.
No, it's okay.
Not often enough. No, the communication is truly broken down, and I think there's a lack of trust, and there's a lack of cooperation.
And the reason that broke down is what, funding?
No, well, initially,
Or
I mean,
new leadership?
It stopped. It's a combination. I think COVID broke the training didn't happen for a couple of years initially because of COVID. It wasn't a priority to restart it, and there hasn't been an attempt to really bridge this divide where correctional staff and healthcare staff don't see eye to eye on how to address people with serious mental illness, and there's not an attempt to get people to start to think differently. I mean, one of the I'll just note, like, the founder of the PACE units, the specialized mental health units at Rikers, was actually a correction officer, a guy named John Gallagher, who's a member of our commission, who for years worked as a regular line officer. He saw people with mental illness. He's like, we can't keep doing the same thing over and over again. He's like, I want to work with healthcare staff and find a better path. And he created this program, which was really remarkable, like just a model for the whole country, frankly, and how we can deal with this with people who are inside. And we just need to get back to that. Like, the structure is there, but the leadership and the prioritization hasn't been. And the folks at Rikers feel like they're just constantly putting out fires every day. They're not being proactive. They're not being...
Leadership would be the commissioner?
The commissioner, I think, means very well, and she wants to, but I don't see her having opportunity, frankly, and to really address these things and be proactive. Like, almost everything that's happening inside Rikers, because the conditions are so dire, is reactive. And when you have these things, that if we could just get some breathing space to start to put these things back in place, training and otherwise, we could be in a better place. We need to be in a better place, and as soon as absolutely possible.
Okay, thank you. And with my little bit of time, my direct question before was, what kind of training and support do peers need to thrive in their roles within the justice system?
So the peers in New York State are certified by New York State. So we have both OMH certified peers, which are mental health peers, and we also have OASIS, which runs a certification process, which are substance abuse peers. What I did was come in the exact middle of that and build the New York City Justice Peer Initiative, where there are certified peers both with mental health and substance abuse, but also the necessary needed lived experience of carceral impacts. And this is a program that I've been running for about 5 years. I've trained, about 500 justice peers. The problem with that is that I get a lot of organizations and agencies who want to come to my training, who want the training, but when it comes time to build an actual employment pathway for a justice peer, my agencies come back to me and say, well, we don't have funding for a justice peer. We have funding for peer support, but we don't have funding for a justice peer. But these are organizations and agencies that work with those who are justice impacted and who suffer from behavioral health concerns. So that's that funding screen that needs to be fixed and replicated. And I travel all across the state doing these trainings.
Thank you so much.
I just want to add that too. Some of the things that may be needed for peer training also is wraparound services. The RAP plan, safety plan, motivational interviewing is an exceptional tool that's used. There's evidence-based practices that peers do use as well. We're not just freestyling, using our story with euphoric recalls and glorifying the past. We have evidence-based practices, evidence-based treatment. It works to meet somebody where they're at, to help develop SMART goals. We use all of those trainings that are effective for peer support. Yes.
Thank you, panel.
Thank you very much. Thank you.
Okay, thank you.
All right, I think this is our last panel today. Indeed. Thank you. Thank you. Okay, let me correct my procedure. Please introduce yourselves one by one, and then we'll start again with your 5-minute testimony each. So starting with you.
Sure. My name is Jane Shim. I'm an attorney and the director of the Anti-Asian Violence Program at Asian American Legal Defense and Education Fund.
My name is Joanne Ferdinand. I'm a retired judge of the Brooklyn Supreme Court.
Hi, my name is Jennifer Parrish. I'm the Director of Criminal Justice Advocacy at the Urban Justice Center Mental Health Project.
Peace and blessings. I'm Chaplain Dr. Victoria Phillips. Everyone calls me Dr. V. And today I'm here as the Director of Community Health and Justice Advocacy for the Women's Community Justice Association.
Hi, everybody. Good afternoon. We're at the end of a long day. Thank you to Senator Fernandez, Senator Ramos for holding this hearing and for inviting me to testify. I'm submitting this testimony on the Asian American Legal Defense and Education Fund's behalf, and I thank the committee for this opportunity. ALDEF is a national legal organization that protects and promotes the civil rights of Asian Americans through litigation, advocacy, education, and organizing. Throughout our 50 years in operation, ALDEF has worked with individuals facing racial violence and harassment, from representation of Muslim New Yorkers after 9/11 to advocacy for people of Asian descent who were targeted during the pandemic. We have also hosted community initiatives that increase access to health care for all New Yorkers, regardless of what language you speak, your immigration status, or how much money you make. In light of this history, we urge the committee to pass the Treatment Court Expansion Act. TCEA makes diversion programs available to individuals with mental illness, cognitive impairments, and/or disabilities. Once found eligible, participants can start on their treatment plans without entering a guilty plea, making services less coercive, which means they will be more successful. By getting to the underlying conditions that can lead to criminal legal system involvement, the bill increases access to health care and helps increase safety and well-being for everyone. During the pandemic, President Trump relentlessly blamed China for the pandemic and racialized the virus through rhetoric not worth repeating here. This grew into blaming not just China, the country, but Chinese people and just Asian people in general for the pandemic. Predictably, many Asian Americans were targeted, seriously injured, or even killed during this period. Some of the people who attacked them had untreated mental illness at the time of the attacks. But as our communities grasped for solutions, criminal cases often only made the trauma and the harm worse. Many people I worked with waited months or even years for the cases to conclude. Law enforcement could be disrespectful and aggressive, and victims' needs and wants ultimately proved to be an afterthought to the criminal legal process. Often, victims who sought our assistance were not even focused on punishment at all, but rather prevention, changes that would stop similar attacks from happening again to others in the future. Unlike reforms that respond to harm that has already been done, TCEA is an opportunity for New York to prevent future harm before it happens. For individuals with mental illness, substance use issues, cognitive impairments, disabilities, the criminal system only exacerbates these challenges. We've heard so much powerful testimony today about all of the issues inside. People are then released back into the community without connection to services or treatment, making it more likely that whatever behaviors cause law enforcement contact will recur. It should be noted that there is no evidence that mental illness is correlated with any propensity to commit offenses, and I want to make that clear because I think there's this idea that everybody, who was attacked during the pandemic or has some mental illness issue. The truth is that only a very small fraction of individuals with mental illness are any more likely to be violent, and they have no more higher propensity to commit any offenses. Really, research shows that most criminal legal system contact among individuals with serious mental illness is a result of the same issues that bring anyone else into its orbit: poverty, unemployment, homelessness. Ultimately, mental health treatment and resources should be widely available and not tethered to the criminal system at all. But treatment courts can be one piece of a broader approach that helps meet people's basic needs and make our communities safer and healthier. Real change comes from meaningful preventive measures. This requires, among other things, adequate and continued funding for housing, treatment, and other programs. We need to begin working on those solutions now, urgently, together as a community. These are not my words, but a quote from an essay written by Justin Go, whose daughter was killed when she was pushed in front of a subway train during the pandemic. I urge the committee to honor this message and move this bill. Thank you.
I
want to thank you for listening so attentively to all the speakers. I think I can offer a slightly different viewpoint. I started the first treatment court in the city of New York in Brooklyn Supreme Court in 1996. I gave more than 6,500 criminal defendants facing felony charges the opportunity to avoid prison in return for court-supervised treatment. Nearly 70% of them were successful, and I happily dismissed over 4,500 felony indictments when they graduated from my court. Today, I'm here on behalf of the New York Association of Treatment Court Professionals, an organization of judges, prosecutors, defense lawyers, treatment professionals, law enforcement officers, court employees, and peers. We work in the nearly 400 treatment courts across the state. To the extent that this act codifies best practices, we support it. Together, New York's treatment courts have saved the lives of hundreds of thousands of residents whose substance use and mental health disorders brought them into our courts. We work in drug courts, judicial diversion, mental health, family treatment, veterans treatment courts. And we believe that a treatment court that follows best practices will improve lives and communities while reducing drug use and crime. We use a unique collaborative approach. It's different from any other alternative to incarceration program. An arrest is a motivation to get treatment. The judge, prosecutor, defense attorney, and treatment providers work together to connect participants with the treatment services and supports they need to change their behavior and lead productive lives. Some of the provisions that are proposed, such as expanding judicial diversion to misdemeanors and more felonies, ensuring rapid enrollment of people in treatment, enhancing the role of peers, and affirming that treatment decisions are based on medical considerations. Those proposals align with best practices and will ensure fairness. There are some of the changes which we think will erode best practices. You've heard today about the lack of available treatment throughout the state, and that means that diversion candidates today remain in jail for too long, waiting for an available slot. We need sufficient treatment capacity before courts send more people. Otherwise, we risk making empty promises of help and causing further delays. You know, when I started my court, the biggest change, and I'm very proud when I hear judges say, you have to expect relapse when you have somebody in a treatment court. When I started, nobody said that. In 1996, you gave people one chance. And if you messed up, and that mess up could be the most minor thing, and as somebody earlier today said, it could happen after 10 months of treatment, people were deemed failures. Treatment courts changed that paradigm. We give lots of opportunities, and our association believes that requiring a guilty plea is critical and essential. We think making pleas the exception is a mistake. It should be made clear in the legislation that judges have discretion not to require a plea. And right now, in all of our opioid intervention courts, where speed is a matter of life or death, people are admitted without requiring pleas. The motivation to change for most treatment court participants starts as the desire to avoid jail or forced hospitalization or a criminal conviction. It takes time to see the benefits of recovery. And that is why retention rates for treatment court participants is significantly higher than for voluntary enrollees. Experience has shown us that a plea of guilty with its acceptance of responsibility and the threat of jail provides a powerful motivation. Without an upfront plea, I have had many people sadly say to me, recovery is too hard. They would rather give up and take their chances. If you want recovery to have a chance, it's important that somebody knows the certainty of the alternative jail. If I could just say two other points. There's a treatment plan proposal in the evaluation, and it says that the evaluation goes just to the defense lawyer and not to the court or the prosecutor. Because the evaluations are done by court employees in most courts, that would simply be unworkable. I could not order someone to do an evaluation and have them not turn it over to me. And modifying the treatment plan without notice to the court is another big mistake. The court team, the treatment team, have all kinds of knowledge about a participant that the treatment provider may not have. So a treatment provider may agree to change a treatment plan without knowing that there's an order of protection that prohibits someone from returning home, or that their family members who live in the house are using drugs or alcohol and it's not a safe environment. So eliminating court involvement in a change in the treatment plan is we think, a mistake. And the last thing.
Okay. We got to move on. I'm sorry.
I know,
We'll
my
continue.
time is up.
Yes, it is, but we'll get to that with answers and questions. Next speaker.
Thank you so much. Good afternoon. Thank you so much, Senator Ramos and Chair Fernandez. We appreciate the time you've devoted to this hearing. As I said, my name is Jennifer Parrish. I go by JJ. I work at the Urban Justice Center Mental Health Project, and we monitor the Brad H. Settlement Agreement, which requires the city to provide discharge planning services to people who have mental health needs and are receiving treatment or are supposed to receive treatment when they're inside. Many of the previous speakers have discussed the strengths of the TCEA to accomplish the task of funneling people back into the community so that they can get the supports and services they need. But I want to talk about what happens when we don't do that and the horrors that this bill will help people to avoid, and that's jail. And I'll specifically talk about Rikers Island and the state prison system as well. These are unconscionable places to put human beings. It truly shows our lack of concern for others that as a society we continue to relegate people to these institutions. And this is especially true for people with mental health challenges, as the treatment behind bars is inconsistent at best and non-existent at times, and it's generally just limited to medication and brief clinical encounters. The jail environment is the opposite of what you need for to recover from mental health needs. It's chaotic, it's often dangerous. People with mental health challenges are frequently victimized in those settings and subjected to solitary confinement. Suicide is the leading cause of death in jail, and these conditions exacerbate mental health symptoms and further traumatize people who most likely had a traumatic experience before they came into the system. In addition, many people with mental health challenges are released from incarceration without benefits, treatment, or housing, often more destabilized than they were when they entered. And even in New York City, where discharge planning services are mandated by the Brad H. Settlement Agreement, people with mental health concerns continue to be released to the community without appropriate services in place. I want to highlight three issues that people with mental health concerns face in jail. The first is the unavailable or inadequate mental health care. Now, providing mental health care to this population is not only crucial for their health, but it's constitutionally required. Yet, the mental health care in jails is often completely unavailable, and part of that's due to the correction officers. The Legal Aid Society and Brooklyn Defender Services had to take the Department of Correction to jail just to get a judge to mandate them to comply with their statutory duty to provide every person access to health care. People miss thousands and thousands of appointments every year. They went back to court to ask the judge to hold them in contempt. And you can also see how this affects people when you look at the State Commission of Correction reports. They investigate every death that happens in custody, and there have been far too many deaths of people at Rikers Island. When you read them, you see what it looks like for people, the treatment problems they have. And the Medical Review Board for SCOC identified that the fact that people are not produced for their medical and mental health appointments is one part of the inadequate care people get. The other piece of it is the care that they get once they get to the mental health providers. And there, the boards recognized in Michael Nieves' death that he needed to be referred to a forensic hospitalization. He shouldn't have been kept at Rikers. He was so decompensated, but they didn't do that, and he died. In another instance, they removed someone from suicide watch, Javier Velasco, who should have been placed on suicide watch and given proper supervision, and he also died in custody. The Medical Review Board ruled that in 4 of these deaths, they could have been prevented if they'd gotten mental health treatment, and they didn't. And these are only the people who died. There are so many other people who are being harmed every single day because they don't get the services. The other piece of it is that the jail environment, period, is unsafe, and Rikers, as you've heard, a judge is going to appoint an independent receiver related to the violence, and the SCOC reports show that as well. They show that people died because there was no officer assigned to the housing unit. They died because a person needed to be on suicide watch, but there was no staff to supervise them. They died because Department of Correction officers saw them harming themselves and failed to get involved in that. And there's a horrific video of that in Mr. Nieves' case. The court communicated in one instance that the person needed to be placed on suicide watch, and they didn't do that. So I know my time is up. I wanted to talk more about solitary confinement and the state prison system. The conditions there are possibly even worse than what's going on at Rikers. Right now, most people are in solitary confinement because the correction officers are not taking them out to their programs or not getting mental health treatment. But we can discuss more of that maybe in the questions.
Yes. Good. Thank you so much.
Peace and bless. Oh, it's still good, right?
Yeah.
Okay, so peace and blessings, everyone. I'm Dr. V, Director of Community Health and Justice Advocacy at Women's Community Justice Association. And there's a lot that has been said today, and there's a lot that I have already prepared to say, but I really just want to stick to the humanity and the community part of this discussion. So we know through evidence-based and research that incarceration amplifies existing problems, right, that one might have. And we also know through evidence-based and research that reentry actually, the focus on reentry should actually begin upon someone's arrest. And today I want to just highlight, when we talk about why people are even brought into the criminal legal system, or why they come back, as Zachary pointed out, about 40% come back within the 47% come back within the first year of recidivism after being released. That's because as an Army brat, I feel like we on domestic soil don't properly protect each other. As a mental health professional, as a chaplain, as someone who worked in nursing for many, many moons, all these titles behind correctional walls as well, I've seen firsthand, from an officer's side, a standpoint, or from a detainee or incarcerated individual standpoint, how systems leave us to fight for ourselves, how systems allow us to be boxed in and then punish us for how we respond. And during the pandemic, well, let me just back up really quick. I got 3 minutes. Okay, let me just back up. As a member of the Jails Action Coalition, we started in 2011. And I'm saying that because we was one of the few people out here advocating around the conditions of Rikers. And I want to speak on Rikers because Rikers literally feeds the state pipeline in the prison system. And I'm so torn because when I listen to Justina, it reminds me of why I started coming forward after working on Rikers and fighting with organizations that I worked for about telling the truth and people always being afraid of the backlash. She mentioned Mr. Ardent. Mr. Ardent died less than 24 hours of being on Rikers this year. Several years ago, I raised the concerns around Mr. Carter dying within 72 hours of arriving on Rikers Island. And I say that because they both had mental health concerns. I say that because systems in the community failed them, the shelter system, the hospital system upon discharge, the court system upon receiving them, and then intake upon arriving on Rikers. Every system they came across designed to help them, assist them, or preserve their life failed them. When we talk about Rikers, we have to understand that anyone going to Rikers literally is being given a death sentence. We know 6 years ago, we have proof that officers put Layleen Polanco in solitary confinement, knowing that she had seizures, knowing that she had mental health concerns. And then we have proof that they laughed at her on video while she died. We have proof in 2013. Bradley Ballard, his death, as barbaric as it was deemed a homicide because of his conditions and lack of access to medical care. Last year in 2024, Charisma Jones from the Bronx, Senator Fernandez, 23 years old, was in Rikers, denied medical care after a reaction to medication because of how officers thought she responded to one other officer. So they thought, let's put her to the side. Let's isolate her. So what? She's complaining about having medical needs. And they let that girl stay in that cell so long that she began to die from the inside out. When I prepared her body for her funeral, it was as if she had walked through a fire. But when she entered Rikers, her skin was just as intact as yours or mine. She burnt from the inside out from a reaction of medication. And we were able to prove upon an investigation by the Board of Corrections that DOC denied CHS Correctional Health Services at least 5 times on the record that we could prove access to her as their patient. And she died July 2024 after suffering a brutal, torturous death. And she was supposed to be released September 2024. You see where I'm going with this? But can I just wrap up in another 30 seconds, please, because I got caught up in that. I want to say, if the DOC has still not corrected what we already knew when they was brought on homicide charges in 2013 with Bradley Ballard, and now we know without a doubt that they have still not corrected it through the death of Charisma Jones. As JJ said, who are the others that we don't know about that have died? Working in nursing behind the walls, I have cried driving across the bridge, leaving people, knowing that they would not be able to fight for themselves. As a brain surgery survivor myself, my heart breaks knowing how hard I have to fight in this community. Sometimes knowing the rights that I know are being denied to me. What does that look like behind correctional walls? This state has lost so much money this year with federal funds being pulled from New York City Department of Health, with millions being withdrawn from OMH and OASIS. We have to step up and fight together. And I want to highlight the women as I close, because we birth a nation. We soothe a crying child's fears. I know in nursing that women who came before me was on the battlefield, and I know as an Army brat, fixing the soldiers, right? And then they would still make it home and prepare a hot meal for the family members, because we do it all. So I'm asking you as leaders before me, fight. Make sure your colleagues, your peers fight, because we have to fight to preserve life. I've birthed a child. I sponsor 47 kids in Jamaica, and that's community. You understand? New York, this is community. Us sitting here today, this is community. People behind the walls do not have community. 68% of those with mental health concerns do not have access to mental health treatment in a correctional facility. Where's the community? My mother's in a military cemetery for us to have rights that I do not see being given to everybody. We need equity. We need life preserved. And we need action now. I'm so sorry. Peace and blessings.
No, thank you so much. I do think that's the crux of this work, especially as the chair of this committee, to preserve life and to save life. And that's the argument sometimes that I do face when we're looking at legislation and just expanding harm reduction. You're allowing people to do more. No, it's keeping them alive so they can get better. So I'm with you on that. Would you like to go first?
Whatever you'd like.
You can start.
Okay, sure. Well, thank you all for your testimony. Judge Ferdinand, I want to start by thanking you for your dedication to this work, for your pioneering work in this field. Can you let us know what type of training is made available for judges when it comes to mental health?
So any judge who chooses to work in a treatment court throughout the state is given an opportunity to attend the New York State Association of Treatment Court Professionals conference. So we hold a training conference once a year, and DAs, defense lawyers, judges, peers.
It's all voluntary.
Those who work for the Office of Court Administration are given time off, and all the expenses are covered by the
taxpayer.
By OCA's budget, yes. They require that people participate in training before going to work in a treatment court. For treatment providers, generally get their own funding.
Who gets to approve who can become a treatment court judge and who doesn't?
So
who has that discretion?
So I was a pioneer, and in the beginning, it was judges who saw the need and presented the idea. Now it's a combination of the local administrative judge appoints somebody, or when I retired, I sought out my own replacement. I found somebody who I thought would be good, and that happens in a lot of courts. A lot of us don't leave our babies without making sure they have somebody taking over. But we all recognize that training is critical, and it's critical. You know, a lot of the people were talking about the silos that decisions are made. A collaborative approach requires that you not only talk to other people in other disciplines, but that you understand what their concerns and issues are.
So what level of mental health training would you say judges receive?
In general, judges?
Yeah, in order to understand whether a treatment plan matches the defendant or not, for you to feel confident enough to opine about a person's medication and that sort of thing.
So judges in treatment courts, and particularly mental health courts, all have the opportunity to attend trainings. There have been trainings throughout the year on all kinds of issues. But one of the things this legislation does, which is very important, is it makes clear that treatment decisions are clinical decisions, and they have to be made by clinical providers. So the judge, before a judge can set up a treatment plan, they need to hear from treatment from a clinical perspective, what is the appropriate treatment.
Do clinicians conduct these trainings for judges?
Yes. I've attended trainings by psychiatrists from Rikers Island, by the center, used to be the Center for Court Innovation, holds trainings. I mean, there are many different ways, and anyone in a treatment court, if you sat in a treatment court for one day without training, you would say, I need to be trained.
Shout out to Judge Linda Proust Lopez in the Bronx, Judge Jessica Earl Gargan in Queens. I've sat in both of their courthouses a few times, and I've been able to witness what goes on.
And they both attend our training conferences,
Yes.
and they train others.
Yes. Dr. Slattery here from Samaritan Village, who is the largest provider in New York State, she testified that they provide services to upwards of 45,000 people, disagrees with you when it comes to requiring a pre-plea in order to see a positive outcome. So if we trust clinicians, and they are saying that the science should not require.
I disagree with her science.
Right.
So in the early 90s, the Brooklyn District Attorney started a revolutionary program, drug treatment alternative to prison. He took second felony offenders facing mandatory jail under the old Rockefeller laws and without a plea of guilty, sent them to treatment. 50% of them failed. Compare that.
Because of the plea. Because of
I
lack of
can't tell you the reason.
Well, so is your science anecdotal or empirical?
Well, the science is that 50% of those people who were voluntarily enrolled failed, while our treatment courts throughout the state have a success rate of around 66, and in many courts higher.
Is this the only instance where you see your science
there's
oppose hers? Who's a doctor?
There's a lot of research on the value of coercion. I just want to say one thing. I've spoken to treatment providers. They tell me nobody's here voluntarily. Either their job insisted that they come, or the court insisted that they come, or their wife insisted that they come, or somebody called it the mommy mandate, the family.
If they're working
Most
class
people don't go.
If they're working class people, how else can they access mental health services?
You're saying people in the community.
So I mean,
I'm an expert in how people in court can access it. How people in the community, I'm less knowledgeable than you.
Okay, I think yes. So for me, it's sometimes people would love to have the help. They don't have the means or access, whether it is cost prohibitive or distance prohibitive.
Or they don't know how to get it. Right. Or they don't believe they can ever get better.
Right.
Or they don't believe
and now
life
they're in this
is worth it.
predicament before you at the bench, and this is the only way that they can access it.
Yes.
So then, would you argue that requiring a plea might be a way for a judge to sidestep liability if something goes
No.
wrong?
So, I'm sorry, I don't recall her name, but she was...
Dr. Slattery.
Yes. So
Yes.
she was talking about... I just lost my train of thought. I'm so sorry.
It's okay. And apologies,
She
Senator
said
Fernandez.
that when she was arrested, if somebody handed her a piece of paper and said, come back to court in the future, put this piece of paper, this is what I say. You say to a drug addict, take this piece of paper, put it with all your important papers, and come back to court in a month. You're not going to see that person. But when you take somebody and you say, you're going to come and get evaluated tomorrow. You're going to see a clinician tomorrow. And they're evaluated before they enter a plea of guilty. They get evaluated, and the judge, the defense lawyer, the prosecutor all take a look at the treatment plan. Now, if the person is not capable of making a decision today because they're in the throes of addiction and they need to detox, nobody would require that person. That's not a voluntary plea. You can't allow that person to enter a plea. But when they're capable of making the determination, the problem with not requiring a plea, and I'm not saying in every case, but the problem with saying there will be no plea, you're going to find too many people who
But
just...
you would agree to leave it at the judge's discretion, whether a plea is required?
Absolutely. But the way it's read now,
Yeah.
it says no pleas unless a very specific
Well,
set
let me
of
ask
facts.
you, Judge
I would-
Ferdinand,
I
in
would
your
flip it.
court, if I was my formerly undocumented mother and I did something wrong, and I came before you and I pled guilty so that I'm able to access XYZ treatment, if I may, finish. I complete the treatment you've mandated of me. I am better. I have my children. But because of that plea, I am now in deportation proceedings, and I will be torn away from my children. Do you think that's justice?
No, that's an injustice. And I pioneered something that's in the legislation now. I did it before it was in the legislation. The legislation now says if somebody will have unintended negative collateral consequences, which is what you just described, somebody who completes their treatment, is successful, has done everything you want, is now a productive citizen, but merely because of the plea they're going to get deported, that's an injustice. And I pioneered a program that's used by other judges around the state that says that person does not
I have
enter
10
a plea.
seconds. I want to ask, throughout your testimony, you've referenced we establish best practices. I am assuming you're alluding to the organization that
association.
you're here to represent. How are the best practices determined by the executive board of that organization, or is that determined democratically?
Research. There's the National Association of Drug Court Professionals has an extensive research arm, and they put out on the issue of medication-assisted treatment. They trained us all. If you are a court that follows best practices, you read what the National Association...
But in terms of pleas, not all of your members agree with you. And it's my understanding that at this past conference in Saratoga, they were told in the audience that this would be the position. Not that it was discussed, not that the professionals were polled. They were told that this would be your organization's position.
So the organization...
How do you know that most of the professionals in your organization support your personal position?
So the board of directors of the association includes a prosecutor, a defense lawyer, treatment professionals, a peer, judges, and the board meets and discusses issues. And
So it's the board's decision.
The board reviewed every version of this bill has been reviewed and discussed by the board of the association. So when I say we object to the prohibition against a plea. We agree a judge should have the discretion, but the way it's worded now, it presumes no plea. And we think that that's wrong. We think it should be, if you made
I understand. And thank you for your testimony, because despite your disagreement, I have tremendous respect for you. I do want to note that everyone else who has testified disagrees with you and are experts in aspects of your work and might be even members of your organization.
Right, but a plea of guilty is a legal issue. So
I understand.
Here is one other thing to think about. If you and the senator had mentioned it, if you allow someone to participate without a plea, my concern is that a judge will say, when they're faced with giving the person the fourth chance, and we routinely give people 5, 6, 7, 8 chances. When you're faced with the fourth chance, and the case is now a year and a half old. And you have to worry, will the witnesses be gone? If I keep this person in treatment for another 6 months and they continue to violate the conditions, and I then send them back for trial, the case will have fallen apart. And my concern is judges will not be inclined to give as many chances if they're worried that the case will have fallen apart.
Sorry for letting that go a little longer, but I
Sorry.
was interested in the answers. But I'm going to defer my 5 minutes to maybe some response by the other panelists. I did see some wanting to share more to that point.
I noticed that you mentioned opioid courts, and opioid courts are a place that you support having no plea. But one thing we know, these are very effective courts, but predominantly the people who participate there are white. There was a study of the Buffalo courts, and this is in the testimony, that they compared it, looking at people who were in the regular court and the opioid court, and the opioid court, white people were 83% of the enrollment, whereas in the other court, where you're not allowed to go without a plea, it's 46% of the population. And just on the diversity point, I will point out that in the best practice standards, equity used to be the second of those best practice standards, and they talked about the need to have equity across the board, and that's been removed from the best practice standards. So,
Equity was removed as a best practice?
yes.
By whom?
I think it's related to a political determination about.
By a federal agency.
So my point is only that that there is a political component to this. That's all.
There's always been a political component to this work. But thank you for that. Did anyone else want to say something? Yes, ma'am.
I'm not going to talk about the federal or anything. I just want to talk about the people who actually go into Rikers and maybe not, judges might not think that they would come back based on the pre-plea. 77% of the women who go in Rikers right now in Rosie's are primary caregivers. So they already have an inclination or a responsibility to make sure that they do right in the sense of the eyes of the court and return home, because they have, whether it's children or an elderly, a loved one, somebody dependent on them because they're the primary caregiver. I also want to highlight that 80% of the women right now on Rikers have a mental health concern. So we heard all day 54% of the population, but I want to narrow that down to about 80% in the women when we talk about them. And I also want to throw in that women go into Rikers, 1 out of 4, already being a survivor of sexual assault. So when we talk about trauma, when we talk about the things that could exacerbate or bring out someone's undiagnosed symptoms, these are all things that occur in the community that if it was properly treated or had adequate resources, or judges were properly trained and educated on the resources in the community, that they wouldn't end up behind the walls and be sitting waiting for advocates like me to come try to help them. And so there are a lot of people in our community when given the opportunity for pre-plea or to not have a plea would say, push TCEA forward, please.
Thank you.
I just wanted to add, put on my immigration lawyer hat for a second, and to Senator Ramos's point on the pre-plea option, Judge, that's terrific that you were able to implement that program, but the issue with the judicial discretion around the plea is that maybe not every judge will, exercise that in their courtroom. And so the legislation, including that presumption in the statute, I think is really necessary to truly guarantee that across the state, immigrants are not facing that type of impossible decision in order to access treatment. So I just wanted to make that point.
Thank you so much. Well, this last couple of minutes gave me a lot of insight and answered questions that I did have. So I think we'll end it here. But thank you so much to this panel, to all the panelists today, to Senator Ramos again.
Thank you, Senator Fernandez.
Well, thank you. It's been great work
Thank
with you. But I think we learned a lot and are motivated to do more. But thank you. Have a great Friday. and I'll see you all soon.
It is Friday.